Welcome to a Legalbytes presentation of the Karen Reed murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Reed case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Reed murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police who Reed says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. All right, you guys, welcome. This is day 24 of the Karen Reed murder trial. Good morning, good afternoon, good evening, wherever you're coming in from. I hope you're having a wonderful day. Happy Thursday, guys. So there is a full day of trial today and a full day of trial tomorrow. As a reminder, tomorrow I am not going to be able to stream because tomorrow/Saturday I'm flying around the world, getting back to the original office, the central office, and yeah, we get to stream from then on with the fur buddies, with all the pets and stuff that we are absolutely missing. I know you guys are. Folks have been saying that. I know I am. Mr. Bites and I have found ourselves increasingly looking through our phones at the photos and videos of all of our guys, and we're just absolutely missing them. So we've got day 24 today and full day, like I said. So we're going to pick up right back up with Detective Lieutenant Tully. We did not finish his direct examination yesterday, so we are going to be finishing that one today. It started a few minutes ago. So we have an opportunity to put it on 1.25x speed right off the bat. As you guys are aware, Adam Lally is a little bit of a slower talker, so which is fine. But it's an opportunity to speed things along a little bit. So we will be going ahead with that. And let's see here. Day 23 recap is out. Lally tally, before I forget, because I almost always forget. Let me pull that up here. Where are we with the Lally tally? Okay, over on Twitter. So after day 22, it was 1,536. On day 23, there were actually 37 that were picked up by the transcript, but one of those actually was by Alan Jackson. So we're down to 36. So total, all in all, is 1,572. Can we get to 2,000 by the end of this trial? I think so. I really do. Even when we eventually transfer over to the defense case in chief, there's a decent chance that we hear some more what if any's on cross-examination from Adam Lally. So, all right. Okay, let's get into it with that. We've got the poll in the chat. And so be sure to answer that when you have a chance. And we've got any kind of questions. Actually, we do have a couple questions. Let me get these before, since they're prior to the opening today. Chris Martin question: what's your thoughts on all the red and white pieces? IMO, there's so many pieces. You could rebuild multiple taillights, planting evidence. The origin of those pieces, the chain of custody of those pieces are highly in question at this point still. The prosecution has not given us any kind of an indication that they are, in fact, secure, that they were secure for the 6 weeks between January 29th, the incident in question, when they say that those pieces first and last landed on the lawn there. And then March 14th, when they first had any kind of a log documenting their chain of custody. And that was when they were first brought into the Massachusetts State Police Crime Lab. So what happened in those 6 weeks with those pieces? Where did they go? Like, did they disappear and then return? Did they go to the upside down? Did they go to space? We don't know. As far as the jury has heard, we have no idea. So I need answers on those. Maybe we'll get those today through Detective Lieutenant Brian Tully. We'll see. But with those questions around them, I can't just take them at face value. Jerry Roth, lurking while walking as per usual. I'll chime in when I can. Legalbytes, Kim Proctor get charged with perjury for what he said about Yannetti yesterday. Like I've said before, perjury is a very big charge, and it takes a lot for someone to go from an inconsistency or even outright lying on the stand to getting a perjury charge. It takes a lot. It takes a lot to get to a perjury charge. I don't know that we're there here at this point. Okay. And also Jackie De Hernandez, question when Bev asked the witness a question after overruling an objection. Is that true? Did you do that? Do you think it influences the witness's response because of the pressure of the judge? I don't know. Maybe, possibly. I mean, you guys let me know what you think. For me, I don't think so, because I think that the way that she says that to the witness is generally with a very friendly tone. Like, did you say that? Is that true? It's much more, she's not harsh when she says it. At least that's the tone that I pick up. But I don't know. Maybe you guys have a different opinion. It's a good question, because we don't want the judge to be influencing the witness one way or another. Also, Dionysia Jaclo, thank you so much for the super chat that just came in. Lally is trying hard not to spill any tea in the Canton Tea Party. Meanwhile, defense passes the sword to one another and pop in their champagnes. I love it. Absolutely. What a wonderful metaphor. That is awesome. Okay, folks. And one more, split personality. Have you caught up on any of the drama in the YSL case from this week? If we thought the KR trial was nuts, that one is a whole other can of worms. I've been following the highlights of it, and I want to get into the deeper part of like what exactly is happening there. But basically, it sounds like there is a good possibility that there is a judge in that case who will not be a judge for much longer, based on what I am hearing, and if what I'm hearing is true. So we will see. But that is just, yeah, it's nuts. Okay. All right, folks, let's get to it. All right. So, okay. Right. Like I said, Detective Lieutenant Brian Tully continuing his direct examination. Okay, maybe we can
state your name and spell your last name for the jury.
Brian Tully, Tully.
Now, Lieutenant Tully, you were testifying yesterday. You were testifying in some part about a search that you did in conjunction with the search team at 34 Fairview on January 29, 2022, right?
Yes.
And at any point in time, did you or any other member of your unit conduct any search of the residence at 34 Fairview Road?
No.
And why not?
We had no reason to believe that the evidence found within the home of 34 Fairview Road.
Now, Lieutenant, if you could you inform the jury a little bit about sort of search warrants as far as residences go, and what is required in Massachusetts for you to conduct a search warrant?
Objection.
So we haven't heard the question. Let's hear the question.
That was the question, I'm sorry.
I thought it was you informed the jury about search warrants and then what?
If I interrupted you,
Complete your question?
I did, Your Honor. Yes.
Okay. So it's sustained then.
thank you.
As far as, Lieutenant, over the course of your career, you've conducted search warrants of people's residences, correct?
Yes.
What do you need to do that?
A search warrant, consent, or exigent circumstance.
And as far as a search warrant is concerned, what is needed or what is necessary in order for you to get a search warrant?
Objection.
Jody, tell Timmy to be quiet. So I'm going to allow him to build a foundation here. So the objections will be.
As governed by the Fourth Amendment of the U.S. Constitution and Article 14 of the Massachusetts Constitution, law enforcement is required to get a search warrant if we're going to invade someone's privacy. In order to obtain a search warrant, I need to gather facts that I swear an oath and affirm that are true and accurate, that there is probable cause, which means more likely than not that a specific piece of evidence will be found in a specific location and it's related to a crime. So I need to check those boxes in order to obtain a search warrant through the trial court.
And what, if any, information did you have related to specific evidence of a crime in relation to the interior of the residence at 34 Fairview Road?
I didn't have any. When thinking about residence in search warrants and evidence, I need to put the evidence inside the house. And so I don't believe that Mr. O'Keefe entered the home. So I had no nexus to the house.
And what, if any, evidence did you have that Mr. O'Keefe had ever entered the home at 34 Fairview Road on January 29th or on any other day?
I don't. On the contrary, I have evidence that he was outside, but I don't have anything putting him inside the residence.
I mean, but it's a little bit of a chicken and egg situation here. He said that he didn't search the home because there was no evidence that he was in the home. But like, what about, you know, other issues here, or other matters that would lead to questions as to whether or not he did go into the home? The connection, the fact that he had been out with the others the night before, the fact that there was, you know, that there was a, you know, a social friendship, for example, the fact that they were all, you know, all, I don't know. There are a number of things that connect all of these people there that I think that if Brian Albert had not been a cop, his home would probably have been searched. That's the impression that I have at this point anyway. And folks are free to disagree with me. But so he's kind of making a conclusion ahead of asking questions that would lead to a different conclusion. That's the problem with his line of logic here about probable cause for the search warrant.
Now, you're aware that, or you testified yesterday that at some point while you and the search team were conducting the search at 34 Fairview, that Sergeant Mechanic and Trooper Proctor were following a tow truck with the defendant's vehicle from Dighton to the Canton Police Department, correct?
Yes.
And in reference to taking the vehicle to the Canton Police Department, how was that decision arrived at? What, if any, discussion, or what, if any, other options did you have?
So Sergeant Mechanic and I had conversations. It was ultimately my decision of where the vehicle was going to go. And so we need to find a location that was secure, indoors, and preferably heated. And so we start going through checklists of what's available. So you start thinking, obviously, of state police facilities. So between Dighton and Canton, where our office is as well, you have the Foxborough Barracks, which was, I worked out of the Foxborough Barracks. The garage was probably not appropriate for that large vehicle to get in there. It's an old building. I worked at the State Police Barracks in Milton. That's even worse, with a smaller garage that's attached inside of an older building. So the Canton Police Department was the next step. It was kind of checked all those boxes. It was inside, it was secure, and it was heated.
Now, over the course of your career, specifically within the homicide units of the detective unit of the district attorney's office, approximately how many investigations have you led or been part of in relation to? Let me first ask you this: as far as your unit is concerned, how is it that, from a staffing perspective, how is it that an investigation is conducted as far as certain roles, or can you speak a little bit about sort of the roles that different people within your unit play with reference to an investigation, just in the general sense?
Within the unit, we have different sections. We have the homicide section, narcotic section, and special investigations. So each is kind of broken up into that. Obviously, the homicide section will undertake homicide investigations, but we work as a team. So there'll be situations where you may need an all hands on deck just to get some people out there. So the narcotics folks will help with homicide investigations, and vice versa. The homicide people will help with narcotics investigations when needed.
Your Honor, may I just have a moment?
Yes.
Jennifer Casal, thank you so much for the super chat. I finally get to see you live. Thank you for all you do. I watch while I work in the main courts. LOL. Well, thank you so much. I appreciate it. Thank you. Thank you.
Specifically, when it comes to death investigation, there's someone who's assigned as what you call a case officer. Is that correct?
Yes.
And can you explain to the jury what the role of the case officer is, and what, if any, other sort of supervision there is with reference to that case officer?
The case officer is essentially the central collection point for the investigation. So they are the person that would gather the evidence, the records, hold those records, and then somebody needs to be held accountable for a to-do list or something to do. Supervisor would go to that one person, as well as the district attorney's office would know who to contact about a certain case, and then we'll go from there. Obviously, that case officer usually is a rank of trooper, especially when you're talking about unattended deaths. They have a sergeant and 2 lieutenants that are supervising them in that realm.
And as far as interviews are concerned, what, if any, sort of policy is there with regard to troopers, and how many would be involved in the interview of any witness?
We would always have 2 people present, either a trooper and a local detective, or 2 troopers. Just one ask questions, one take note taking. It's just good practice.
And with respect to this investigation, the locals, as far as Canton Police Department, was not something that you utilized, correct?
Correct.
And again, I know you testified a little bit about it yesterday, but if you could just reiterate or expound upon sort of what your discussions were with the chief as far as Canton Police Department's involvement in this investigation going forward following the early morning hours of January 29th.
Our conversation circled around in the early hours about the homeowner of 34 Fairview, which was Brian Albert, has a brother, Kevin Albert, who was a detective with the Canton Police Department. And so where we were, we had essentially zero information about the investigation. We wanted to remove any appearance of conflict by not having Kevin Albert or any of his coworkers involved in the investigation.
Was that in the investigation in its entirety or the interviewing process, or how was that sort of delineated, if at all?
Definitely no interviews. They were not involved in any discussion. Essentially the entire investigation.
And as far as the case officer is concerned, is the case officer someone who, particularly in a homicide investigation, is as far as a decision regarding charging, is that something that the case officer would be tasked with?
No.
Now, turning our attention back to your testimony yesterday, there were items that you had retrieved from the search on January 29th, correct?
Yes.
And as a precursor, if I could ask you sort of, over the course of your career, specifically within the homicide unit with the district attorney's office, about how many death investigations, homicide investigations have you been involved?
I would say in excess of 600 unattended death investigations that I personally investigated. That's not counting those phone calls that the calls I end up declining that I'd mentioned yesterday. In addition to that, I probably have either worked or supervised 75 homicides. And then getting back to the unattended deaths, I've supervised countless since I've attained the rank of trooper and lieutenant. Sergeant and lieutenant.
And with respect to your training and with respect to your experience, how many of those investigations have involved injuries which included abrasion?
Probably 10 to 20% of them.
And if you could, at least from your understanding, if you could explain to the jury what your understanding of what is an abrasion.
Objection.
Sustain.
Right. He's not a doctor. He can't do that.
With regard to the items that you recovered on January 29th, there was one piece of clear plastic you testified yesterday had something that you termed as stippling on the outside, correct?
Yeah, I may have used the word dimples, but yeah.
Now, with respect to Mr. O'Keefe, at some points, did you have occasion to view photos of Mr. O'Keefe from the Good Samaritan Hospital?
Yes.
And with regard to the items that you recovered, what, if any, significance did you observe between those items and the injuries that you observed to Mr. O'Keefe?
The injuries to Mr. O'Keefe, I noticed the abrasions had a certain pattern on them. And I know that when a blunt force object is involved in causing an abrasion, the characteristics of the object that comes in contact with a person will often leave the characteristics on that person in the form of an abrasion.
And with respect to this specific case, as far as any items recovered on January 29th and your observations of Mr. O'Keefe, what, if anything, did you observe of any significance in relation to that?
I'd be comfortable in saying that the marks on Mr. O'Keefe are consistent with.
Objection.
Sustain.
Yep. He can't. He's not a doctor. That's
Now, sir, if I could
outside
turn
the
your
scope
attention.
of his expertise. Lally keeps wanting to have these police officers testify as to medical information, medical conclusions, medical causations. Like, this is stuff that they cannot. It doesn't matter how many times they've seen, road rash in some kind of an incident on the highway, or blunt force trauma to the head in a homicide case. It doesn't matter. They do not have the training, expertise, or education in order to be able to make those kinds of conclusions. Also, they haven't even been offered as an expert witness in order to be able to render any kind of an opinion or any kind of a conclusion. So, regardless, even if they kind of could sort of bootstrap that in, they're lay witnesses. They have to testify to what they saw, what they heard, what they felt, what they tasted, what they smelled, the five senses. They cannot testify to anything having to do with some kind of a conclusion or an opinion on something, unless it is like their impression based on what they had seen, that is a very like a human kind of response to something, like a communication, or what someone said, for example, and the impact of what someone said on this person's mindset. Like, this is on the witness's mindset, not someone else's, because that's speculation too. So this is Lally keeps trying to get this stuff in, and now at this point, since we have not even heard from the medical examiner, it makes me wonder if the reason why he's trying to get all this in is because he thinks he's not going to be able to get it through the medical examiner for some reason. The reason I say that is because we have a good suspicion that the medical examiner's conclusions are not what the DA would like them to be. We know that the manner of death apparently is undetermined. It's not homicide. So that's an issue for the prosecution. So anytime he can get some sort of a conclusion from someone that happens to be a cop in front of him, and try to sneak that in because of their experience investigating these kinds of things, he's going to try, it sounds like. But yeah, he can't. That kind of stuff they cannot testify to.
Two other members of your units are troopers by the name of Trooper Dunn and Trooper Moore. Is that correct?
Yes.
And on February 2nd, 2022, are you familiar with them retrieving some video in relation to this investigation?
Yes.
And specifically from the town of Canton, did they retrieve video from there?
Yes.
And specifically, what location did they retrieve video from?
From the Canton Public Library at 786 Washington Street.
And are you familiar with them speaking with a gentleman by the name of Mr. Jutras?
Yes.
He's an IT person with the town of Canton.
Yes.
And as far as the timestamp with regard to the video that was retrieved from the Canton Public Library, what, if any, information do you have in reference to that?
Whenever we retrieve video, we want to ensure the timestamp is accurate, because as we've learned, businesses are not always great about updating the timestamp. So that's always top of mind when we collect video. Mr. Jutras ensured us that the timestamp on the video was consistent and in real time.
Now, the following day of February 3rd, you familiar with Trooper Moore retrieving some additional surveillance video?
Yes.
And where did he retrieve that video?
From Temple Beth Abraham in Canton at 1301 Washington Street.
Now, as far as those two locations, as far as the Canton Public Library and the Temple Beth Abraham, are you familiar with where they are in relation to each other?
Yes.
Both located on Washington Street, is that correct?
Yes.
And about how far away from each other are they?
About a mile and a half.
Now, with reference to the Temple video, what, if any, information did you receive in regard to the timestamp on that video?
That was also accurate.
Now, from each of these respective locations, what time frames was Trooper Moore in one instance and Trooper Moore and Trooper Dunn in the other instance? What time frames of video did they retrieve from each of those respective locations?
From 12 a.m. midnight to 1 a.m. and from 5 a.m. to 6 a.m.
And why was it that those were the time frames, based on what you learned to that point in the investigation, why were those the time frames that the troopers were looking for?
We had reason to believe that those were the times that Miss Reed's vehicle was traveling in and around that area.
And I'll get to that a little bit more in a moment. But as far as reason to believe that, that Ms. Reed's vehicle was traveling in the area around those times, what, if any, information did you have to base that on?
We had statements and video from the Waterfall Bar and Grill, also on Washington Street, a little bit further down, and a car departing in that direction. We had information about a car that matched her description arriving at 34 Fairview at a certain time, shortly before 12:30 a.m. And so, like we always do, we do out a video canvas and look for video cameras from that first known point, which would be the Waterfall Bar and Grill, to the residence of 34 Fairview. And then from there, from 34 Fairview to 1 Meadows Ave, which was the home of John O'Keefe.
In reference to the morning hours between 5 and 6 a.m., the later morning hours between 5 and 6 a.m., what, if any, information did you have in relation to Ms. Reed's travel at that time? So
we had learned through interviews that she was calling people as early as 4:45 in an effort to locate Mr. O'Keefe, and a statement that she had left the house shortly after 5 a.m. We then know that she arrived at the McCabe residence on Country Lane after 5:30. So we're trying to account for the movements of the vehicle for that 30-minute block.
Now, in reference to phone calls, you've had occasion to review information related to the defendant's phone.
Yes.
Now, you mentioned that about 4:45 in the morning, she made phone calls trying to ascertain, or allegedly trying to ascertain the whereabouts of Mr. O'Keefe. Is that correct?
Yes.
Prior to those 4:45 a.m. phone calls, were there other phone calls that the defendant placed?
Yes.
And to whom did she place those calls, and about what time?
Starting at 12:33 a.m. to 6:03 a.m., there were 53 phone calls from Ms. Reed to a phone number associated with John O'Keefe.
And in addition to those phone calls to Mr. O'Keefe's phone, what, if any, other calls did the defendant make prior to those 4:45 a.m.?
There were phone calls to her family members, to Jennifer McCabe, Kerry Roberts, Camaranos. Those are the ones off the top of my head. I have the notes in front of me if I want me to refer to them.
You all right, the witness may?
Yes.
Would you like me to continue, ADA Lally?
Yes, please.
After 6:03, when Mr. O'Keefe was found, there are a number of calls to members of John O'Keefe's family.
No, the phone calls to family members of her own, the defendant's family members, those were specifically to her mother and her father, is that correct?
Yes.
And did those phone calls precede the phone calls to either Ms. McCabe or Ms. Roberts or anybody else earlier that morning?
On the call detail records, they don't appear, but I know the phone dump has other information.
Your Honor, may I approach?
Yes.
Lieutenant, turning your attention back to the videos we were speaking about, showing you a disc, just asking you to recognize that.
I do.
And what do you recognize that to be?
It is surveillance video from Temple Beth Abraham.
May I approach, Senor?
Yes.
I want to see if you introduce the minutes next exhibit.
No objection.
Thank you.
Exhibit 572.
572.
May I approach again, Your Honor?
Yes.
Another document. You recognize that, sir?
I do.
And what do you recognize that to be?
It is a map I created with icons of the town of Canton.
And how did you create that map, sir?
Using Google Earth as the mapping software, I placed icons on locations within the town of Canton that are relative to this investigation to provide better context and illustrate the area that we're going to be discussing.
May I approach again, Your Honor?
Yes.
I want to see if you introduce the minutes next exhibit.
No objection.
Thank you. Exhibit 573.
Carmen Brown, thanks for the super chat. OMG,
Your Honor,
can
may I
Lolly
return
please
to
stop
the
clearing his
573
throat?
minutes?
Yes.
Your Honor, with court's permission, if I could
Thank
publish
you.
that to the jury at this time.
Yes.
Lieutenant, do you have the laser pointer there before you? Okay?
I do.
So using that laser pointer, if you could direct the jury's attention to the icons that you inserted a reference to various points of relevant locations, as well as any sort of route to travel or roadways depicted in this video.
So each icon is a house-shaped icon that I placed at different locations. The first one is red in color. It denotes where 34 Fairview Road is. Starting at the bottom, there is a pinkish color one that is the location of the Waterfall Bar and Grill. Just north of that, you'll see a brown one, which denotes the Canton Public Library. Following up this street here, which is Washington Street, you'll come to Temple Beth Abraham, which is denoted by the blue icon there. And then off to the right is One Meadows Lane with the green icon.
Now, as far as, and if you could just use that laser pointer again to know where the temple is.
It is the blue icon in the center of the map.
Now, as far as where the temple is located in reference to specific roadways, it's, you mentioned, located on Washington Street, correct?
Yes.
And so what if any roads intersect with Washington Street around the location of the temple?
Chapman Street is the street that runs in this direction towards Washington Street. So again, the Washington Street is this street here. It continues and stays Washington Street as it turns slightly east in that direction.
And as far as available points of directionality or ways to travel roadways from the area of the temple, it intersects in the area of Dedham, is that correct?
Yes.
And so as far as available routes of travel from Temple to 34 Fairview, if you could note those on the map.
If one was at the temple and were to travel to 34 Fairview, you could continue up Washington Street, take the left onto Dedham Street, which is that street you just mentioned, a left onto Cedar Crest, and to enter that neighborhood down here. One could take a left and come down Chapman Street and take the right to enter the neighborhood in that direction, straight onto Fairview Road.
And if you're approaching sort of from the Chapman Street side of Fairview Road, as you come down Fairview Road, which side of the road would 34 Fairview go?
Left.
And similarly, if you're approaching from the Cedar Crest side of Fairview Road and turn on Fairview Road, which side of the street would 34 Fairview Road go?
Right.
Thanks. Now, with respect to each of these videos, as far as the Canton Public Library video and the Temple video, these are exterior cameras, is that correct?
Yes.
And sort of orientation-wise, where do they focus on or where are they pointed?
The ones that we focused on were the ones that captured Washington Street.
Now, are you aware of another location right around the area of Temple Beth Abraham called Cassie's?
Yes.
And that's essentially like a convenience store, is that right?
Yes.
And were you able to, you or other troopers able to retrieve video from that location as well?
I don't believe so.
Now, Your Honor, with the court's permission, if I could publish portion of the video from the Canton Public Library, which is marked as Exhibit 110.
Yes.
And Ms. Gilman, if you could, from the first video,
Folks in the chat saying we've earned the Californias. You know what? You're right. You're right.
I know a shortcut through El Segundo. Take the 105 West and exit on Cabo. When you see the Zanko chicken on the left, turn right. Take Venice and follow it all the way down. Then you're in Marina del Rey.
Right. At least this time we got a map to go with it so that we could actually follow along with what they're saying instead of having to like try to memorize different words without any context. All right, let's see this footage from the library here.
From the time on the video, I'd actually go to about 12:50.
I'm sorry, 15 or 50?
51. Now, again, for orientation purposes, Lieutenant, if you could,
so?
using the laser pointer, just describe to the jury sort of what we're looking at here directionality-wise and what you observe in this video.
The main street in the video is Washington Street. The Waterfall Bar and Grill would be off to the right-hand side, and Temple Beth Abraham would be off to the left. The intersecting road we're looking at here is Sherman Ave, I believe.
And if one were to take that right, if you're coming from the right of the screen to the left of the screen on Washington Street heading towards Sherman, and you were to take that right on Sherman, where does that take you?
You would head towards the neighborhood that 1 Meadows Ave resides.
Now, were you also able, over the course of the investigation, did you have occasion to look at surveillance video from the Waterfall Bar and Grill itself?
Yes.
And from that video, were you able to determine a time at which Mr. O'Keefe was leaving from that establishment?
Yes.
And what, if any, observations as far as time, or what, if any, observations did you make as far as what Mr. O'Keefe was doing or had with him when he left the office?
When he left shortly after midnight, he was holding what appears to be a clear glass container.
And do you recall which hand he was holding it?
His right.
And specifically, that was about 12:11 a.m., is that correct?
Yes.
And Ms. Gilman, if you could, I'm going to ask you to press play here and then pause again at 12:15:58. Now, looking up at the screen now, where it's paused at 12:15:58, Lieutenant, what, if anything, did you observe there?
I observed a large black SUV here on Washington Street.
And the large black SUV that you observed, is that consistent with what you observed of the defendant's vehicle?
Yes.
And if you could describe to the jury as far as when I asked Ms. Gilman to press play, what is that vehicle going?
It's going to continue north on Washington Street through the intersection on Sherman and continue north on Washington Street.
And what, if anything, is sort of in that directionality as it continues off of the screen to the left?
Be heading towards Temple Beth Abraham.
Ms. Gilman, if you could. Ms. Gilman, you can pause it there. Now, with respect, Your Honor, with the court's permission, if I could publish portions of the Temple video,
Yes.
and just as a continuing, my intention would be to sort of go back and forth if that's all right with the court.
Okay. Yes.
Here's the thing. We really only care about seeing this car out on the road if we are looking
one moment,
for the
Your
tail light. If the tail light is broken. So if this is just going to be showing how she got from the Waterfall Bar and Grill to 34 Fairview Road at 12:15 in the morning, I feel like this is kind of a waste of time because we don't care.
And if you could,
He's
thank you.
obsessed with this route.
Again, for orientation
But we don't
purposes, Lieutenant, if you could describe using the laser pointer there as far as what we're looking at in this particular camera angle and shot, and as far as the roadways that you.
This is an exterior camera from Temple Beth Abraham at 1301 Washington Street. Where it's paused now at 1201, I believe is the timestamp. You see a vehicle here. That vehicle is traveling on Washington Street. We are now on the other side of Washington Street looking at it than we were from the library. So the south and towards the waterfall and the library would be off to the left. North would be off to the right.
And Ms. Gilman, if you could fast forward to 12:17. If you could pause it. Now, as far as the time concerns, the video from the prior video from the library was about 12:15 a.m. when you saw the vehicle consistent with the defendants pass by that location.
Yes.
And so as far as this time that's up here now, approximately 12:17 or so, or somewhere within that minute between 12:17 and 12:18. Is that consistent with the time it would take to travel from where the library is on Washington Street to where the temple is on Washington Street?
Yes.
And from this particular time period around 12:17, between the minutes of 12:17 and 12:18, what, if anything, did you observe with reference to, of significance with reference to this investigation on this portion of this video?
At approximately 12:17 and 56 seconds, you'll see a large black SUV travel from left to right on the screen, which again would be northbound.
And again, left to right on the screen, for orientation purposes, what is in the direction from left to right on the screen as far as of any significance to this?
As you continue north on Washington Street, you would, I believe the next intersection on the left is Dedham Street, which one could take to get to 34 Fairview Road.
And Ms. Gilman, if you could, and I would ask you again to follow the 12:17. And again, Lieutenant, directing your attention to the screen, and if you could, using the laser pointer, direct the jury's attention to what, if anything, of significance you observe in this portion of the video at 12:17:56 from the temple.
A large black SUV traveling northbound on Washington Street.
And the large black SUV, is that consistent with the large black SUV that you observed in the prior video, Exhibit 110 from the Canton Public Library?
Yes.
Is that also consistent with what you observed as far as your personal observations of the defendant's vehicle?
Yes.
Gentlemen, if you could please press play. Gentlemen, you can pause that. Take that down, please. Ms. Gilman, if I could ask you for the Canton Public Library video again. And from this, I'm going to ask for from the second video. Now, Lieutenant, direct your attention to up on the screen. This is the Canton Public Library video again, Exhibit 110.
Yes.
And as far as this is the time frame that you were talking about before, between 5 a.m. and 6 a.m. that Troopers Dunn and Moore retrieved from Mr. Jutras, correct?
Yes.
And with reference to, as far as the conditions outside at this particular time between 5 and 6 a.m., what, if anything, did you observe in this video?
The ground is now covered in snow.
And Ms. Gilman, if I could ask you to fast forward to about 5:11 a.m. and pause it there. Now, Lieutenant, from this portion of this video from the Canton Public Library, what, if anything, of significance did you observe in this portion of the video relevant to this investigation?
You observe a large black SUV take a left from Sherman Street onto Washington Street, heading south.
And as far as the directionality from where that vehicle came from and the directionality where that vehicle is headed toward, what, if any, of the locations of significance are located in those areas?
So again, Sherman Street or Ave goes straight to One Meadows. So if one were to travel from Meadows Ave, the residence of John O'Keefe, to this location here, you would come down Sherman and you could take a left onto Washington Street to head south.
And as far as south on Washington Street, again, off to the right of the screen, what, if any, locations of significance in this case are located in that direction?
The Waterfall Bar and Grill.
Now, as far as the black SUV that you observed in this video, is that consistent with the black SUV you observed in the Temple video from 12:17 a.m.?
Yes.
Is it also consistent with the black SUV that you observed in the library video from 12:15 a.m.?
Yes.
And is it also consistent with the defendant's black SUV?
Yes.
Now, with reference to, are you familiar with Mr. O'Keefe's home having ring cameras affixed to it?
Yes.
And are you familiar with a video from those ring cameras depicting the defendant back in the black SUV out of Mr. O'Keefe's garage at approximately 5:07 a.m.?
Yes.
And from that, as far as distance or time it would take to travel from Mr. O'Keefe's residence to this intersection covered by the Canton Public Library from 5:07 to 5:11, now depicted on the screen, is that consistent with the time it would take to drive that, particularly given the conditions?
Yes.
And Ms. Gilman, if you could, please press play. Ms. Gilman, if you could pause that. Now, Ms. Gilman, if you could fast forward to about 5 minutes, I'm sorry, 15 and 30 seconds. Pause there, please. Now, Lieutenant, between these timeframes of 5:11 a.m. and 5:15 a.m., at any point in time, do you observe the black SUV traveling back in the other direction?
Yes.
And specifically around 5:15 and 51 seconds, what, if anything, did you observe on this video of significance or relevance to this investigation?
A large black SUV will appear on the screen on the right-hand side and travel to the left-hand side, which again would be traveling north on Washington Street.
Now, as far as, again, directionality, north on Washington Street to the left of the screen would be towards the temple. Is that correct?
Yes.
And as far as the operation, as far as directionality is concerned, what you observe in this area from 5:15 a.m., is that consistent with what you observed on the Canton Public Library video earlier at 12:15 a.m.?
Yes.
And again, as far as the black SUV that you observe in this, it's consistent with all the other black SUVs you observed in the video and the defense video, right?
Yes.
And Ms. Gilman, if you could press play. You could pause there. And Lieutenant, if you could, using the laser pointer you have before you, direct the jury's attention to where you observe the black SUV.
Here on Washington Street near the intersection.
Again, using that laser pointer, if you could just indicate to the jury as far as directionality where this vehicle is going to head on.
North would be to the left-hand side of the screen towards Temple Beth Abraham.
Ms. Gilman, if you could press play again. And if you could pause there, Ms. Gilman, you can take this one. Now, Ms. Gilman, if I could ask for the Temple Beth Abraham video again. And Your Honor, may I have just one moment?
Yes.
You can pause there, Ms. Gilman. And for the record, this is from the Temple Beth Abraham video. This is from the period of 5:10 a.m. to 5:20 a.m., which is the second video listed down within those. Now, Trooper, with regards to this video, at some point around 5:18 a.m., what, if anything, did you observe of significance or relevance to this investigation from that period of video?
A large black SUV travel left to right on the screen.
And again, as far as directionality, where would that vehicle be coming from, and where would that vehicle be heading to?
The left side of the screen would be in the direction of the Canton Public Library and the Waterfall Bar and Grill. Off to the right, again, would be the intersection with Dedham Street, which one could take to 34th Fairview.
And as far as directionality, with reference to the earlier video from 12:17 a.m. from the Temple Beth Abraham, is directionality consistent in this video with what you observed at 12:17 a.m.?
Yes.
Now, Ms. Gilman, if you could play from 5:18. And Lieutenant, what, if anything, do you observe in this portion of the video relevant to this investigation?
A large black SUV traveling north on Washington Street.
That's about as clear as mud. I mean, the problem with all of the surveillance footage right now is you can't identify any kind of a license plate. You can't. I mean, how many cars are on the road between 5 and 6 a.m.? Of course, like that does increase the likelihood that this is in fact Karen Reed's car. But you know, the graininess of these images, maybe what they are going to be doing is also bringing in the data from her Lexus SUV, the infotainment system, because those nowadays, especially if they've been purchased within the last like 5 or 10 years, they have computers in them that will give you GPS information. This is something that we learned during the Caitlin Armstrong trial when they just buried her with digital forensics. They placed her with amazing accuracy outside, like just outside, parked outside the residence of the victim at the time that they had that she was killed. And so, you know, all of the digital forensics between ring footage and cell phone data and the infotainment system in the car, those are all things that will help to place a vehicle and a person driving that vehicle, more importantly, to a very specific location. So this is one of the reasons why I kind of feel like this surveillance footage just feels a little bit, if they were going to introduce this, I think that a better way of doing it would be introducing this after the infotainment system, because then you can say with reasonable certainty, like, yes, this is there. And this footage would just be confirming that. But starting with this, I'm looking at this and I'm like, this is very grainy. This is not exactly very clear that we can really look at this and say, are we sure that this is Karen Reed's car? So this is just a critique that I have as to the strategy of putting all of this evidence in front of a jury, who, by the way, now has a lot of questions as to what not just the police investigating this case have been gathering and not gathering and putting in front of them, but also the prosecutor himself, with that inverted footage really can do damage as to how they look at something like this that is grainy, that is ambiguous, that is a little bit of this shady gray area of like, how much do we actually trust what he's putting in front of us? So, starting with something like this, which is, like I said, a little bit ambiguous, is not the best way to go about it. The better way of doing it is starting with something that they can really hang their hat on, which is something like the infotainment system. I would so much rather start with something like that.
And again, is that large black SUV that you observed here consistent with the large black SUV you observed in the prior videos and also consistent with the defendant's vehicle?
Yes.
And Ms. Gilman, if you could please press play again. Thank you, Ms. Gilman. You can take that to me. Mr. Officer, we can have the lights back up. Now, Your Honor, if I could just have a moment.
Sure.
Yeah, and also James Games Classics. Why does Lally seem to waste so much time going over what is undisputed by the defense like this? He does it so unconcerningly too. And I will agree that this is something that does seem to be undisputed. No one disagrees that Karen Reed was there at 34 Fairview Road at 12:15 or 12:30 in the morning, right? Everyone agrees that she was there. The other question is, like, was she there between, before 6 a.m., between 5 a.m. and 6 a.m.? Did she drive around, see that he was there and continue driving around to try to like make this whole show to the other people that she was calling and dragging out of bed to try to go and find him? That's what the prosecution is claiming. That's the part of that's the area of time that is a little bit cloudy right now, that would be helpful one way or another to have evidence to clarify. The times between 12 and 12:30 a.m. we don't really care so much about, because it's relatively undisputed. You don't have to go through all of this effort if no one is fighting over it.
In the course of your investigation, are you familiar with what time it was that the defendant, approximately what time it was that the defendant arrived at Ms. McCabe's home?
5:35 approximately.
And Ms. McCabe's home is located on Country Lane, is that correct?
Yes.
Now, from the directionality of that vehicle in the 5:18 a.m. Video, as far as timing is concerned, 5:18 to about 5:35 or so, is that consistent with the time it would take to drive from that area of the Temple Beth Abraham to Ms. McCabe's residence on Country Lane?
No, not if you were to drive directly there.
And so to that point, as far as what about that time doesn't match up? Is it too short, too long, or something else?
It would take you much quicker to get there. It's about 1.5 miles from Temple Beth Abraham to Country Lane. You would continue north on Washington Street and just take a left into the Country Lane neighborhood. So the time to travel 1.5 miles.
And from sort of the distance between either that Temple video and either 34 Fairview Road or Country Lane, were you able to find, locate, or retrieve any surveillance video in those areas that would capture the vehicle?
No.
Now, as far as you had mentioned earlier in your testimony, when we were talking about the earlier 12:17 a.m. Portion from the Temple Beth Abraham video, the directionality of that black SUV, both in the 12:17 and 5:18, where is Fairview Road in relation to the directionality of the SUV that you observed?
That SUV could take a left onto Dedham Street and then a left on Cedar Crest to enter down to Fairview Road.
And from your knowledge of the area as far as travel is concerned, would from 5:18 to about 5:35 or so, would that allow for sufficient time to go from where viewable on the Temple Beth Abraham video for the vehicle to then travel to 34 Fairview Road and then travel to 12 Country Lane.
Yes.
Also, I forgot to mention this before. Carmen Brown, thanks so much for the super chat. Oh, also, I'm new to Bike Club. You're awesome. Thank you so much for that. Thank you for the super chat and for joining Bike Club. And if you guys are really interested in the best way to support the channel, Bike Club is a great way to do it. Fantastic way, either through YouTube memberships or through Patreon, so that we can continue to devote all of these resources into time and energy and research and editing and all that good stuff, into live streaming and doing these recaps and other videos on other similar topics, other trials, other one-off situations that we also cover. So awesome. Thank you so much. Shout out to you, Carmen Brown, for joining. And also Veronica B, shout out to you for gifting one Legalbytes membership to someone else. So Reznov Vasilevsky, welcome back to Bike Club. Very happy to have you here. And Veronica, thank you so much for that. And also, folks, if you guys are unable to support the channel yourself by joining Bike Club, even just liking the video really does help to push this out to YouTube. It shows the live streams and the videos to more people, which means more people come in and watch. Then there's more AdSense. So even though it's nothing out of your pocket, it's like the easiest thing to do to actually support the channel. And it really does help to make it so that we can actually dedicate all of this extra time to this trial and to similar subjects. So thank you so much, guys, for all of that. If you haven't done so already, please do like the video. It really does help.
Now, I believe you had mentioned earlier in your testimony that at some point there were call detail records that were obtained in reference to the defendant's phone.
Yes.
And can you explain to the jury, as far as, let me ask you this first, with regard to call detail records and with regard to phones in general, what, if any, specialized training have you received or have you given in reference to those areas of focus?
I've received over 200 hours of training relative to obtaining and using call detail records and cell phone data in furtherance of criminal investigations. Most recently, I've given talks and seminars about the topic, and I've testified in numerous courts around the Commonwealth about the topic.
Now, can you explain to the jury sort of call detail records, what they are, and how you would use them as far as utility in generally speaking in reference to investigation?
Call detail records are business records held by cell phone companies, specifically to this matter, that are created in the normal course of business. Typically, you think about in a billing context. So if you think of your own cell phone bill, it would contain information like the date and time a communication occurred, the other phone number in which you communicated with, the duration of the call, that sort of bits of information. Obviously, as we're doing a criminal investigation, it's helpful to know with whom someone was communicating. Additionally, the cell phone companies memorialize other bits of information specific to what we refer to as CSLI, cell site listing information. They tell us the antennas that were used during the communication, usually just in the form of the first antenna and the last antenna. There are other engineering records that we can obtain that can be helpful when trying to determine where the handset, the cell phone was at any given time.
And the handset that you refer to is essentially the phone itself, correct?
Yes.
And with relation to the handset and its connection to antennas or towers, can you speak a little bit about that based on your training and experience with reference to how the handset sort of communicates with an antenna and how it gets to a specific antenna?
Cell phone companies place antennas all around to help facilitate communication. You can think of a cell phone as really a two-way radio. It's sending and receiving radio waves. So in order to facilitate that, cell phone companies place these antennas all around. Traditionally, you can think of them on a tower, but they can also be placed on the side of buildings or disguised as trees or just on top of light poles. So they're all around, but you don't quite know it. As far as how the handset communicates with the antenna, there are different variables that go into that. Now, the cell phone wants to connect to the antenna with the strongest signal. The best predictor of a strong signal is distance. So the further a radio wave travels, the more it's going to degrade and not be as strong. But there are other factors that can degrade or reduce the strength of a radio wave, specifically obstruction. If you're in a basement of a building or standing behind a large brick wall, the radio waves aren't going to penetrate that as well. But even things like precipitation or foliage on a tree can also hinder it. And you think about rolling hills here in Massachusetts in tall buildings, they can also disrupt radio waves.
So this is one of the big things that I have wondered about the pinging of these towers, these cell phone towers for determining where someone might be. Now that is something that can be very helpful in a case. And like I already referenced the Caitlin Albert case where that was the love triangle murder trial, the cyclists that were in this supposed love triangle in Austin, Texas. And in a place like Austin, Texas, there are hills in Austin, yes. And in the Austin area. However, within Austin itself, it's a much more sort of populated area. And so there's a lot more cell towers that are in there. It's a bit more reliable to be able to use cell phone towers in a place like that in order to get a relatively accurate location for someone. Now, when we're talking about the Idaho College or the Idaho University murders, the college students who were murdered, and trying to figure out was Brian Koberger responsible for it. That's one of the things that they've used in order to arrest and to charge him for their murders. But the question there is the cell towers that they were using were in areas that were much more sparse. So they're a bit further away. The accuracy is a bit more not circumspect, is a bit more questionable, I should say. So in an area like this, he just mentioned, foliage, less likely in winter, of course, because there's not so much foliage on the trees, but rolling hills, things like that can definitely interfere in something like this. So what I'm really looking for, in this testimony is, what is the area around Canton? I don't know as a total outsider. I want to know, is this a hilly area? Is it relatively flat? Is this an area that has more cell towers, fewer cell towers, things like that? I'm really hoping to hear that from this particular witness so that we can gauge what kind of accuracy we can even pull from these sort of cell tower pinging bits of information one way or another, either pro prosecution or pro defense. All right, let's listen in and see what he says.
Now, as far as that sort of disruption of radio waves, are you familiar with certain areas that get termed as a dead zone?
Yes.
And can you explain what your understanding of that term is as it relates to what you've been talking about as far as the handset communicating with the antenna?
I would find a dead zone as an area where there's not good cell phone coverage. So the antennas are not covering that area for whatever reason, obstruction, the density of the tower. Oftentimes, an antenna can only handle so many cell phones at a time. It's an idea that we coin or refer to as load. So there's only a certain number of devices that can handle an antenna. My best analogy of that is Gillette Stadium. I've worked at Gillette Stadium detail many times. We have roll call for Patriots game early in the morning. I take my post. I have strong functionality on my cell phone. As hundreds of thousands of devices are now entering the area around Gillette Stadium, the functionality of my cell phone reduces as more devices are using the antennas in that area.
Now, with respect to the cell phone companies themselves, they create or utilize this data for their own business purposes, correct?
Yes.
And can you just briefly explain a little bit about sort of what the cell phone companies would be using this kind of data for as far as what you're talking about, connections to antennas and towers?
It's a company, wants to make money, so it's going to memorialize things to bill their customers appropriately. They're also required by the FCC to keep, for a certain period of time, certain records because they are a communications provider. So there are some requirements, regulatory, that they need to fulfill.
Also, this is a good question here. El Borre, he isn't an IT professional and wouldn't qualify as an expert. How does he get the okay to comment? It's because he does have training in this particular area. They did lay a foundation for that to say that he often uses this kind of like forensic evidence in his cases, and he has been trained on this kind of stuff. So he has a baseline foundation of information, of understanding, of training to be able to understand this stuff and to be able to explain it. Now, whether or not he can opine on conclusions, he might be able to do some to a certain extent, like that's still within the orbit of what he normally does in his profession using this kind of stuff. But in terms of like an expertise, unless they have otherwise determined outside of the presence of the jury that he is an expert witness here, they're not going to be able to have him give like very big broad conclusions about this stuff. But he can definitely explain how this stuff works and how he uses it in his work in order to investigate a case.
Now, as far as the information that you're able to glean from these call detail records, I believe you've spoken a little bit about, but as far as what, if any, limitations are there with reference to the information you're able to glean from the records?
Well, the overarching one is I can only get what I get. So whatever the company sends me, that's what I can use in my determinations. Kind of the next step is when we're talking about antennas. I will never, well, I'll have difficulty saying exactly where a cell phone was when using an antenna. I can make generalizations that the phone is going to be in the area of the antenna, but I would never, with just that specific information, be able to tell you exactly where it is. I can look at other records, like engineering records, where, especially now with 4G and 5G technology, the cell phone providers need to know how far away a handset is from the antenna in order to facilitate that communication. And they keep those ranging records for me. So if I can obtain those records, I can then place a much narrower area where a cell phone would have been during a time period.
Now, in reference to this investigation, you the search warrant that Trooper Proctor did with regard to call detail records from Ms. Reed's phone, correct?
Yes.
And were you able to, or did you have occasion to look at those call detail records?
Yes.
Your Honor, may I approach?
Yes.
Your Honor, may we approach this sidebar briefly?
Sidebar.
Page document just has to look with us.
Yes.
Sir, I'm showing you a 4-page document just has to look at the company finished. You recognize that document, sir?
Yes.
What do you recognize it to be?
It is the subscriber information for the phone number ending in 9554.
And through the course of your investigation, as far as that phone number ending in 9554, who, if anyone, did you find that number to be associated with?
The defendant, Karen Reed.
Now, with respect to the documents before you, that has some listing of account information, is that correct?
Yes.
And who is listed as the subscriber for that account with phone number ending in 9554?
Karen Reed of 481 Gilbert Street in Mansfield, Massachusetts.
And are you, through the course of your investigation, familiar with that address, 481 Gilbert Street?
Yes.
And is that the residence of the defendant?
Yes.
May I approach, Your Honor?
Yes.
Call more to introduce in the minutes of next exhibit.
No objection.
Exhibit 574.
I'm actually going to see counsel at sidebar for just a minute.
Just gonna ask.
Okay. Another sidebar. Another opportunity to fast forward.
Now, Lieutenant Tully,
Did we mark that, Madam Court Reporter? Thank you. So that's 570.
574.
4.
All right, go ahead, Mr. Lally.
thank you, Your Honor. Now, as far as the information that you receive with reference to call detail records, is there a section called the records key?
Yes.
And can you explain to the jury what a records key is and how you use that in order to facilitate a read the records?
The records key give us the definitions of terms that are used in the record. So the record comes usually in the form of a spreadsheet or PDF. You'll get columns and rows. The columns will be named certain things, and those titles are often specific to the company. So I want to make sure that I'm reading and understanding what the data is.
Now, I believe you alluded to it earlier in testimony, but just for the jury's edification, if you could describe to the jury what your understanding of the term as far as cell site listing information and how that's used in an analysis of call detail.
So CSLI, as it's referred to, has that billing information, time, date, duration, other phone number, and it has the antenna used during the communication. So just as it says, it's a cell site, which is the other term for antenna, as I usually use.
Now, sir, through your training experience, are you familiar with the term in reference to this type of material called ranging data?
Yes.
And can you explain to the jury what you understand that term to mean and how it's used in interpretation of call detail records?
So the ranging data goes back to the engineering reports I had mentioned earlier that can provide more information. They can tell me the antennas that were used during communication. It can tell me the range in which the handset was away from the antenna. So now, opposed to just kind of making general determinations where a handset was near an antenna, I now have a range. So I will plot the location of the antenna, measure out that distance, and draw an arc with that radius of the distance on a map. And I can make an assumption that the handset is somewhere on that arc. The ranging data is also helpful because the user does not need to be actively using the phone in order for a record to be created. Right? The billing record is going to be a phone call made or received, text message made or received. A cell phone, as it sits today, is still communicating with the antenna. You're getting notifications, it's checking email, it's updating, and because it's utilizing the network, your cell phone provider is capturing that data and it's generating a record, even though unbeknownst to the user.
Okay, so to that point, or illustrated with that point, so if I'm standing right here with the cell phone in my pocket, not using it, not turning it on, not activating it in any way, that cell phone is still doing some sort of communication with the closest or some antenna within the vicinity.
Yes.
Now, you're also familiar with
Really quick, Kevin Whalen, thanks so much for the super chat. Anybody else thinking Lally brought this case just to let bad cops immolate themselves on national TV? Well, I would think so, except for the fact that it doesn't reflect very well on Lally either, or the DA's office in this area also.
the term called UTC or Universal Time Code.
Yes.
Can you explain to the jury what that term means and how it relates to these types of records?
So UTC, or now known as Coordinated Universal Time, is the time zone along the prime meridian. So if you think of the globe, you got longitude and time zones. The prime meridian is a spot that runs through Western Europe and in Western Africa. That is the line in which all time zones around the world are predicated. And UTC would be a time there, and it's not determined by daylight savings time either. So all those time zones, like I said, around the globe are predicated on that. Because it's one standard time in a globe, a lot of records will come in UTC time, and you have to make the conversion. And they will provide records specifically to a cell phone, what time it was locally, but it will tell me what the UTC time was. So for me to figure out what the time was locally during the time of communication, I got to do the conversion.
And to that point, as far as the conversion is concerned, what type of conversion are we talking?
Here on the eastern side of the United States, it's -4 hours during the summer and -5 in the winter.
Now, as far as these records are concerned, what, if any, I believe you spoke a little bit as far as the arc and plotting, but if you could expound upon that as far as explain to the jury what it is exactly you're able to do with the information from call detail records as far as a visual representation.
You said two things there, so I want to make sure I answer the question right. You mentioned ranging data, but CSLI, so specific to the engineering report in ranging, or CSLI?
Let's first start with CSL.
So with the CSLI, I will place on a map the location of the antenna. And I mentioned load a little bit, but that load factor determines on how dense the antennas will be from placed by the provider. So if you think of an urban environment, there's more cell phones, there's more devices that need antennas. So the locations of the antennas will be more dense. I've seen them as close as 100 yards away from each other in an urban environment. You come out to the suburbs, there are less devices. The company's going to put less antennas because they don't want to put them up where they don't need to. They're going to be further away. So in Norfolk County, the antennas are placed anywhere from 1 mile to 4 or 5 miles apart.
And so there would be a difference as far as the amount of antennas, the amount of towers, like say in the town of Canton versus downtown Boston.
Yes.
And again, I think it's pretty clear, but which of those two, as far as downtown Boston and the town of Canton, would have more antennas or more towers for a cell phone to connect to?
Downtown Boston would have more.
And so with relation to the number of antennas or towers that a handset or cell phone could connect to, what, if any, relation does that have to geographic location, or what you're able to glean in reference to geographic location from the call detail?
So once I place the antenna on a map, I will look at where the other antennas are, and I can make a general determination that the cell phone was closer to that antenna than other antennas. Again, there's a caveat, and I'll say it up front, is that there are other mechanisms that could prevent it from connecting to the closest tower. But generally, it's going to connect to that closest tower. Now, there are redundancies built into the system. If an antenna goes down because it gets struck by lightning or needs service, there are other antennas nearby that can cover an area.
Now, with respect to the CSLI data, we were able to do that in this case as far as plotting that on a visual representation on a map.
Yes.
May I approach?
Yes.
So what he said about the suburbs having fewer towers than like really urban areas, for example, that's what I was talking about with sometimes towers are in an urban area, you have more towers because you have more people. So sometimes you can get more accurate information actually from those towers than you can in those more sparsely populated areas. So the suburbs, he said, have fewer than urban areas, but do they have fewer to the extent that they are far less reliable than what is appropriate in this case? Still a question. Hopefully we can get an answer to that as well.
Document just asked you to review that when we finish. Did you recognize that, sir?
Yes.
What do you recognize that?
It is a series of maps that I created depicting the records obtained from that number ending in 9554.
And that's plotted onto sort of a Google image or a Google Earth image?
I use Google Earth to create the maps. I then take a screenshot and place it typically in PowerPoint in order to make it look nice.
May I approach on?
Yes.
Almost to introduce and admit collectively, isn't it? Is it?
No objection, Your Honor.
575.
Thank you.
May I return that to the witness, Your Honor?
Yes,
May I have a moment, Your Honor?
yes.
So, Lieutenant, directing your attention to the second page therein. And Your Honor, with the court's permission, if I could publish this to the jury.
Okay.
Lieutenant, do you recognize what's depicted now up on the screen?
Yes.
And Dan, what do you recognize this to be?
It is a map that I created using the information from the call detail records of CSLI from that account.
And from what time period of call detail records are we looking at in this particular representation?
From 12:33 a.m. to 12:34 a.m. Again, I had done the conversion for the purposes of making this exhibit. So if one were to look at the call detail records, you may see the UTC time. For the convenience, I've done the conversion for the purposes of the exhibit.
Now, sir, if you could, using the laser pointer, before you direct the jury's attention to what, if anything, of significance you've plotted out, of course, into this visual representation.
So first, we're looking at the area of the town of Canton. I've placed different landmarks, again, to give context to what we're talking about here. You see 34 Fairview Road as a yellow house icon, 1 Meadows Ave, Canton as a darker color, and the Waterfall Bar and Grill as another icon. Now, off to the left, just west of
Cannot see
Route
that.
95, which you'll see running here.
So that is supposed to be the icon for the Waterfall Bar and Grill. It's basically black. This is supposed to be the 1 Meadows Ave indication right here, and that is also basically black. I would have completely missed those had he not pointed them out. I mean, I saw Waterfall Bar and Grill and 1 Meadows Ave, but like this and this those are totally camouflaged on this map.
You'll see a red triangle, which I use consistently as the antenna, and a series of letters and numbers next to them. So next to them is the numbering system that Verizon assigns to that antenna. So in this instance, we're looking at ENB, which is the antenna acronym, and specifically 57171.
And to be clear, as far as that marking with the red triangle, the ENB ID 57171, that is the antenna that the handset or the defendant's cell phone is connecting to at that point, correct?
Wait a second.
Yes,
I
and,
need him to point out where that is again.
and in this instance, we're looking at ENB, which is an assigned, and a series of letters and numbers next to them. So next to them is the numbering system that Verizon assigns to that antenna. So in this instance, we're looking at ENB, which is the antenna acronym,
Me.
and specifically 57171.
Cursor's me.
And to be clear, as far as that marking with the red triangle, the ENB ID 57171, that is the antenna that the handset or the defendant's cell phone is connecting to at that point, correct?
I think that's the triangle. That's supposed to be a red triangle. I'm not colorblind, so like I should be able to see a red triangle on a greenish black map. Like I think it's there. I think this is like really poor work on this one to try to, I mean, this is a demonstrative, right? The whole point is to demonstrate to the jury very clearly what it is that you're talking about, to aid in explaining what you are supposed to be talking about. But also, this is a very interesting point. Alexa Sidaran, Legalbytes ENB is Evolved Node B, which is a cellular base station, not an antenna. So he may be using his own terminology for some of these things, which is, you know, jury may not know one way or another. But if it ultimately gets to the same crux of things, then maybe that's okay. I don't know. Well, we'll see. But thank you for that clarification.
Yes, and I always try to be clear that is the antenna. That's not where I'm saying the handset was.
So the handset is somewhere in that vicinity based on your training
And when he's talking about a handset, he's referring to her cell phone.
experience, is that correct?
Yes.
And Ms. Gilbert, if we could have the next slide. And so what time period are we looking at in this particular representation?
12:35 to 12:37 a.m.
And again, if you could, using the laser pointer before you, direct the jury's attention to what, if anything, of significance or relevance you depicted in this representation.
So those same icons appear as about the locations relative to this investigation. You'll see another red triangle here, close to Route 95, which is
It's right there.
NEB ID 57286. And during this time period, the handset associated with this account communicates with that antenna.
And from the locations of significance or relevance as far as ENB ID 57286, which of them is it closest to in this depiction?
It's just north of 34 Fairview Road.
And now if I could direct your attention to the next, Ms. Newman, if I could have the next slide. And Lieutenant, what time frame are we looking at in this slide?
This comes from one call that occurred at 12:38 a.m.
And as far as, if you could again, using the laser pointer, direct the jury's attention to what any other locations you identified or signified in this representation.
Again, same icons for the south to bottom. The antenna is located here at the intersection of routes 93 and 138, and it's ENB ID 57021.
And of those locations of interest that you signified within this slide, where is ENB ID 57021 in relation to those?
If you think back to the previous slide, so now we've moved a little bit further east. Here's Fairview Road, and here is 1 Meadows Ave.
And if I could direct your attention to the next slide, and if I could have the next slide, Ms. Newman, please. And Lieutenant, what time frame are we looking at in this one?
12:39 a.m. to 5:08 a.m.
And again, if you could, using the laser pointer, direct the jury's attention to what any locations of significance you note in this slide.
So there were a series of calls during this time period. They all used this antenna here, ENB ID 57199, which is south of Meadows Ave.
If I could direct your attention to the next one, please. If I could have that one, please. And Lieutenant Tully, what are we looking at as far as time frame in this particular slide?
There was one entry in the call detail records at 5:16.
And again, using the laser pointer, if you could direct the jury's attention to what, if any, locations you denoted within this particular slide.
I'll start with the antenna that was used, which was 57259 here in downtown Canton, just north of the Waterfall Bar and Grill.
If I could direct your attention to the next slide, sir. Lieutenant, what time frame is that in this slide?
5:19 a.m.
And again, if you could, using the laser pointer, direct the jury's attention to where the antenna is that the phone is connected to at this point, and what, if anything, is closest to it.
Slightly further south from the previous one, it's 57199, directly south of 1 Meadows Ave.
Question from Janet. Technically couldn't defense object because he's not a cell phone tower expert. Well, he's not getting into expert witness territory here. He's getting into basic digital forensics using this kind of stuff. You know, he has laid a foundation here to be able to talk about this stuff, to show that he sufficiently knows what he's talking about because he uses it in his investigations. It's the same thing as someone being able to use, you know, observations about someone's injuries, but without them being able to talk about, you know, blood spatter patterns and what they mean, right? Like there's a difference between that and then them being able to say, well, you know, I saw that he had a laceration above his eye and he had, you know, abrasions on his arm. And this is, you know, I have seen this kind of thing before, you know, and then there's a limit as to how far they can go after that. But, you know, there is stuff that he can testify to about digital forensics because of the fact that he uses it in his work on a regular basis. And he has been trained in it. So he has so far not gotten into the realm of expert opinions. He really is just showing what he looked at and how he got it, and a basic foundational understanding of how this stuff works, which is, so far, in my opinion, so far it's okay.
Now, if I could ask you to turn to the next slide, Mr. Newman, if I could have that one.
And also further questions, I'm still saving,
Lieutenant,
just
what
so you
time
guys
frame are we
know.
looking at in this?
5:20 a.m. to 5:37 a.m.
And again, if you could, using the laser pointer, direct the jury's attention to where the antenna is and what, if any, of the locations you observe it, where it is in reference to those.
I previously mentioned this one here at the intersection of Route 93 and 138. It's ID 57021. It's north of those locations I mentioned earlier, the 34 Fairview and 1 Meadows Ave.
And next slide. What time frame are we looking at in this, sir?
It's one entry at 6 a.m. from the record.
And if you could, again, using the laser pointer, direct your attention to the antenna and where it is in relation to locations of interest in this slide.
It is located just north of the Waterfall Bar and Grill in downtown Canton.
And the next slide, sir. What time frame are we looking at in this slide, sir?
6:03 to 6:57 a.m.
And again, using the laser pointer, if you could, direct the jury's attention to which antenna the defendant's cell phone is connected to at this point and where it is in relation to locations of significance or relevance throughout the course of this investigation.
During this time period, the cell phone will bounce back and forth between two antennas. So I did lump them together and place them on one map with this time frame here. So you will see two antennas. One is this one here, just west of Route 95, which is 57171. The other antenna is north of 34 Fairview, which is 57286.
Now, sir, as far as the locations that you observed from looking at the CSLI information from the defendant's phone, if any relationship did you note with them in relation to what you had observed on each of the respective videos from the Canton Public Library and the Temple Beth area?
It's consistent. As with anything in our investigation, we want to get corroborating information. So the best corroboration about the location of a handset is to obtain video, receipts, anything else with a timestamp and a location that we can corroborate the location of a handset.
And with respect to information that you received as far as the defendant's whereabouts, what, if any, consistency or corroboration was there between witness accounts of the defendant, including the defendant's own statements, as far as where she was and what she retrieved from the CSLI?
Objection.
Ask it differently, Mr. Mayor.
Yeah, it's pretty compound.
Throughout the course of the investigation, were you made aware of path of travel attributed to the defendant both between the hours of 12, between the times of 12 a.m. and 6 a.m.?
Yes.
And the information that you obtained from the CSLI records, was that consistent with what you knew as far as the location of the defendant?
Objection.
Ask it differently, Mr. Mayor. The objection is sustained.
With respect to what you knew as the path of travel of the defendant, the information that you obtained from the CSLI, what, if any, relationship was there between that and the path of travel you knew of the defendant?
Objection.
I'll allow it.
It's consistent.
But also, I was expecting to see something from the prosecution, like with those cell phone towers, something before 6 a.m. pinging off of those cell phone towers that are on the, just west of 34 Fairview Road or just north of 34 Fairview Road, indicating that she had gone back at some point to go and look at it. That's what it sounded like from what I had heard about this case before, it sounded like that's where the prosecution was going to be going with it. But nothing that we've seen so far from this forensic evidence here from these cell phone towers is inconsistent with what the defense seems to be saying, even, which is she went and dropped him off at 34 Fairview Road and left him there after they got some kind of an argument. She says he went inside. That obviously is disputed by both sides. And then she says she went home, freaked out, started driving around, went to Jen McCabe's house, and then eventually they got to 34 Fairview Road at 6 a.m. So I don't quite understand. I mean, okay, the prosecution has to make their case, right? They still have to make their case regardless. But there's nothing here that is particularly, I don't know, it's a bit of a nothing burger is how it feels, really. So, yeah.
Now, sir, as far as the ranging data, what, if anything, were you able to do with the ranging data in relation to a visual depiction of that?
Similar to the maps we just saw using Google Earth, I made a visual representation of what the records display, specifically where the antenna is. But I took that additional step to measure the distance out from the antenna that's depicted in the records and draw a semicircle line depicting where that range would lie.
May I approach the witness, sir?
Yes.
Pages, ask you to look at that and I can push it. Do you recognize those documents, sir?
Yes,
What do you recognize those?
a series of maps I created using the ranging or engineering report.
May I approach, Ron?
Yes.
I'm also seek to introduce him as the next exhibit.
No objection.
Fit 576.
And Your Honor, may I return them to the witness?
Yes.
And with the court's permission, if I could display them to the jury. It's now marked as 576.
Okay.
Now, turning your attention to the second page of what's now been marked as Exhibit 576. Is that what's up on the screen? What you have before you is Exhibit 576, the second page in. Is that what's up on the screen, Lieutenant?
Yes,
Now, if you could, again, what time frame are we looking at here?
12:17 a.m.
And again, sir, if you could, using the laser pointer, describe to the jury what's depicted in this particular slide.
So two locations that, again, as a frame of reference, 34 Fairview Road in Canton and the Waterfall Bar and Grill are depicted with icons. You'll notice a red lollipop would be the best description icon here.
What?
And next to it, you see
There's, hang on. Now this has to be a seeing eye image, because I don't know what he's talking about with a red lollipop. Does anybody else see this? Am I blind? Let me make myself smaller on the screen here. No, I want to make the image bigger. Maybe like this. Okay, here we go. What is he talking about? Red lollipop. I've got it. Let's go back to see maybe where he indicated.
in Canton and the Waterfall Bar and Grill are depicted with icons.
Okay, so there's that.
You'll
one.
notice a red lollipop would be the best description icon here. And next to it, you see a number and the words either first or last. This one.
Yeah, I mean, I see 3 first and I see 3 last. I have no idea what he's talking about with a red lollipop. I mean, yeah, link space. Maybe the camera's just not picking up these maps very well. That's one possibility. However, they did start off with maps that were sufficiently clear with the coloring of those icons. So I don't know. I hope the jury can see this better than we can. I really do, because this is very frustrating for me to not really be able to see what it is that he's talking about.
3 first or in last. If you were to go back to the record or the ranging report, you would go to line 3, and that's where you would find this record. So it's just an easy way to cross-reference the map with the documents. With these ranging reports, it gives me the range that the handset was from the antenna at the beginning of the communication and at the end of the communication. So that's the first range and the last range. That's why we're using those words. You'll notice a line that goes straight out to the semicircles. That line denotes what's called the azimuth, and I've failed to kind of describe what an azimuth is. So as antennas are placed in these locations, they're pointed in a direction. Now, they're not typically a 360-degree antenna. Some are, but mostly they're not. They're pointed in a direction and have a beam width. Rule of thumb, and as you'll see with the records with Verizon, it says typically it's 120-degree beam width, because they'll place 3 around a circle and get 360 degrees. So with this record here, I know what the azimuth is. I then draw a semicircle in each direction. I'll go beyond that 120 degrees just to give deference to maybe it was on the outer edges of that. So I want to give the tie to it was maybe further away. So that's what's depicting on the map.
Okay, I'm not gonna lie. So far, I've been pretty good on the what he's describing as antennas and handsets and all that kind of stuff to understand what he's talking about. His explanation just now went completely over my head, and maybe it's because I was busy trying to figure out where that lollipop was that he pointed out first. But I don't understand what he's talking about with an azimuth. I've never heard this term before. I don't know what that means. The 3 first, 3 last. If it's okay with you guys, I'm going to go back just a little bit just to see if I can understand what he said the second time around. I apologize, guys. I just want to be able to understand this here. Okay.
Bar and Grill are depicted with icons.
Okay.
You'll notice a red lollipop would be the best description icon here. And next to it, you see a number and the words either first or last. This one, 3 first or in last. If you were to go back to the record or the ranging report, you would go to line 3, and that's where you would find this record. So it's just an easy way to cross-reference the map with the documents.
Okay. I'm not going to lie. I don't understand what he means by that. Going back to a record, the third line, I don't know. I don't know what that means. I'm sorry.
with these ranging reports, it gives me the range that the handset was from the antenna at the beginning of the communication and at the end of the communication. So that's the first range and the last range. That's why we're using those words. You'll notice a line that goes straight out to the semicircles. That line denotes what's called the azimuth. And I've failed to.
Okay. So there's this line is the azimuth. I've never heard that term before. This is the semicircle. There is a semicircle here. So maybe, is that what he means by lollipop? If that's so, I don't know what kind of lollipops he's ever eaten in his life. But there's this sort of like semicircle here that is very faint too. I really hope the jury can see this better than we can. There's this line here that is an azimuth. Okay. All right. Sorry.
To kind of describe what an azimuth is.
I'm going back 5 seconds. Sorry.
The semicircles, that line denotes what's called the azimuth. And I've failed to kind of describe what an azimuth is. So as antennas are placed in these locations, they're pointed in a direction. Now, they're not typically a 360-degree antenna. Some are, but mostly they're not. They're pointed in a direction and have a beam width. Rule of thumb, and as you'll see with the records with Verizon, it says typically it's 120-degree beam width because they'll place 3 around a circle and get 360 degrees. So with this record here, I know what the azimuth is. I then draw a semicircle in each direction. I'll go beyond that 120 degrees just to give deference to maybe it was on the outer edges of that. So I want to give the tie to it was maybe farther away. So that's what's depicting on the map.
Okay, so I think that basically what all of that is supposed to translate to is that semicircle is the ultimate range of that particular like possibility of where the handset could be on that map in relation to the antenna or the tower that he's talking about, the cell tower.
Now, with reference to this
I think.
semicircle itself, if I could ask, is the semicircle that is being drawn, what does that exactly denote as to the location of the handset itself?
The report is telling me that the handset is somewhere on that semicircle. So the phone could be anywhere from here on the semicircle all the way around to there on the semicircle.
So again, it's not denoting sort of that the handset of the phone is within the confines of the semicircle, but actually on the line that you've drawn.
Correct.
Oh.
And if I could ask you to flip to the next slide, Ms. Kim, the next one, please. Now, with reference to what's up on the screen now, Lieutenant, what time frame are we looking at here?
5:18 a.m.
And again, if you could, using the laser pointer for you, draw the jury's attention, or direct the jury's attention to what, if anything, was significant to observe in this slide.
So the 2 icons are again appear on the map: Waterfall Bar and Grill, 34 Fairview Road. Here is that red lollipop, which is the antenna that's used during the communication. The azimuth, or the direction in which the antenna is facing, is depicted on there, and 2 semicircles. The first one and the last one. As a frame of reference, I failed to put the Temple Beth Abraham, which would appear right here.
Now, from this, what's depicted in these last 2 exhibits, as far as what you're able to plot out from the CSLI and the ranging data, what, if any significance did that have as far as in reference to the investigation and the handset or the defendant's phone?
It's important to figure out the movements of someone that we're investigating for crime. So these ranging records really narrow down the scope of they're somewhere around this antenna to it's possible they were somewhere on this line. Again, these records are just depicting where the handset was, but as we all know, we all travel with our cell phone within arm reach.
And again, it's in reference to this ranging data in the last 2 slides here. What, if any, relationship did you find that to have with other information, being videos and witness statements that you obtained during the course of the investigation?
So as we previously showed, Temple Beth Abraham, which would be located here, just south of this intersection here, depicts a large black SUV traveling north on Washington Street. That SUV is similar to the defendant's. And with this record here, a phone associated with the defendant was somewhere on this arc at that exact same time.
So may I have a moment, Chairman?
Yes.
Oh,
Morning.
okay. That's going to be cross-examination then.
Thank you, sir. I have no further questions.
Good morning, Lieutenant Tully.
Good morning.
And we're going to put this at regular speed.
I'm not going to go in any particular order, so forgive me if I bounce around just a little bit.
Like a cell tower.
You indicated that on direct examination this morning that you didn't seek a search warrant for 34 Fairview, the interior of 34 Fairview, correct?
Yes,
To your knowledge, nobody under your supervision sought such a search warrant either, correct?
correct.
You explained that in your mind, there was no probable cause to seek a search warrant for the interior of the home. Is that right?
Yes,
But you also admitted that you didn't seek consent, for which you don't have to have probable cause if you get consent, correct?
correct.
You could ask me right now, hey, Alan, can I look at your cell phone? If I say, sure, you do your thing, right?
I could.
But for a court to order that I hand over my cell phone, you got to get a search warrant, sign an affidavit, and get a court to agree with it, correct?
Yes,
You've applied for myriad search warrants in your career, I'm guessing.
yes,
Very experienced, correct?
supposedly.
And I expect that there have been circumstances, Lieutenant Tully, in which you sought a search warrant and the judge says, no, I don't think there's enough here, correct?
Yes.
You don't get in trouble for that, correct?
With whom? No,
With the court.
no,
Well, it's not illegal.
it's not illegal.
You don't get sanctioned for it. You don't get your pay.
What he's about to get at, what he's getting at in this is, where is the harm in asking for a search warrant, even if you think that you maybe won't get it? No one even tried. They all concluded that they wouldn't have reasonable doubt, or not reasonable doubt, sorry, probable cause to get a search warrant. So, there was no determination by a judge that there was no probable cause. This was a conclusion that the police made, which, hey, maybe, they've been doing this long enough that they can make that conclusion. And it's a relatively accurate conclusion that you kind of know how things are going to play out. So why put your resources into that instead? So that, that could be the answer there coming from, or the rebuttal from the prosecution. But he's making a valid point here saying, okay, but did anybody try? Did anybody ask if they could get into the house? Did you even try to get a search warrant to search this house? No one was and because the reason is because no one was actually interested in going into the house. That's the real reason why. It wasn't because of probable cause. It's because no one actually asked the questions to actually move forward potentially with that.
Docked because you don't get a search warrant based on an affidavit, correct?
Correct.
So there's no real sanction in seeking it if you in good faith believe that there's a reason to seek it, correct?
Outside of the time that it takes to author it and put it together and go to the court, yes, there's no sanction.
Of course. But in a homicide investigation, you're not going to fail to do certain investigative tasks because it takes time. You're going to do what is necessary for the investigation, correct? Yes. Of course. You indicated that you did not believe that there was information sufficient that y'all had at the very initial stages of the investigation to seek a search warrant or to ask for consent, correct?
Yes,
But you did know the following. In the initial moments of the beginning of the investigation, you were aware that John O'Keefe had been invited to a party inside a home, correct?
yes,
You knew that that home was located at 34 Fairview.
yes.
You also knew that John O'Keefe arrived at 34 Fairview, correct?
We believe so, yes.
You also knew at the time that he had been, for want of a better phrase, partying with the individuals who were inside the home, correct? Expected to meet at the house.
They were at a bar previous to that, yes.
You're aware that a drinking glass was found in the yard attendant to or close to, adjacent to where Mr. O'Keefe's body was found.
Yes,
That drinking glass had been broken, correct?
yes,
You're aware that drinking glasses are commonly found inside homes, right?
as well as bars.
As well as bars, right? But at that point, you didn't know. It's just a broken glass, correct?
It's a broken glass, correct.
You also know that he was found without a coat on.
Yes,
Are coats normally worn outside or inside?
it's user's choice.
Fair enough. 18 degrees, you would expect that if someone was outside, they'd have a coat on, correct?
I'm the kind of person that wears shorts throughout the year. I'll often go without a jacket.
That's
All right.
fair. There are those
The true
types.
Bostonian.
Yes, sir.
He didn't have any coat, gloves, scarf, nothing like that.
Correct,
He had no winter gear on whatsoever, correct?
correct.
Under ordinary circumstances, and you may be the exception, but under ordinary circumstances, if someone was out in 18-degree weather, you might expect that they would have some winter garb on, correct?
Objection.
Sustained.
So what he's getting at here, what Alan Jackson is going through is a bunch of points about why there could in fact be probable cause to search inside 34 Fairview Road. And he's going to go point by point about like, all right, so did you know about this? Did you know about this? Did you know about this? Okay, you knew about all these things and yet you did not seek a search warrant. So, okay, that's what he's getting into.
You certainly would expect that if someone took their coat, their glove, their hat, their winter gear off, you might leave it inside the house, right? Rather than outside the house.
Objection.
I'll let you answer that, Detective Lieutenant.
It's probably predicated on where you take it off.
Right.
And your relationship to the location.
Right. Reasonable assumption might be the winter gear might be inside the house.
Objection.
Is that a reasonable assumption, Detective Lieutenant?
No, Your Honor.
It's not reasonable that he would have it.
Just really quick, Paige Price, thanks so much for the super chat. Lollipops for the mods. Wonderful. Yes, super props to the mods, of course, as always, for being here and helping to guide the chat and discussion. Make sure that people are agreeing and disagreeing, but doing so in a way that is, of course, always civil, right?
Jacket inside the house? You wouldn't just assume that?
Well, using the term "the house," you talking about any house? 34 Fairview?
Correct.
No, it's not reasonable.
All right. You didn't think it was reasonable at the time
Still don't.
to even ask. Could he have had a jacket off inside the house? And I'm talking about at the time,
Yeah,
the
that's
initial
that's
stages
a
of the
strange
investigation.
response.
Who am I asking this question to?
So I'm asking if you believe it was reasonable if a man is found 30 feet outside the front door of a home and he's got no winter gear on whatsoever, that perhaps he came from inside the home not having donned his winter gear.
Objection.
Can you answer that, Detective Lieutenant?
It's not reasonable, given other information I had.
You also know that he didn't have a shoe on, correct?
Yes.
Where might you look for the shoe if you didn't find it out by his body initially?
Well, the question's not accurate to the facts we had at the time.
Well, the facts you had at the initial stages, I'm talking about just after 6:37, 7:30 in the morning, when the investigation was beginning. During those times, you didn't have any information about where the other shoe was, except he just didn't have a shoe on at the hospital, correct?
We didn't know there was a shoe not accounted for until after noontime.
So when you did find out that there was a shoe unaccounted for, one place to look might be outside, correct?
Yes.
And another place to look might be inside the home, correct?
We looked at the former and we located it there.
You also are aware that a body is being dragged by the shoulders, could easily lose a shoe.
Objection.
Sustained.
Have you ever experienced a homicide in which a body is dragged and you're aware of a shoe being pulled off while the body's being dragged?
Objection.
I'll allow that.
I don't have experience with that.
Certainly not outside the realm of possibility as a professional investigator.
It's possible.
You were also aware that, at least initially, it appeared from accounts that John O'Keefe may have been involved in a physical altercation, correct?
Possible.
As a matter of fact, that was reported by one of your subordinates, Yuri Buchanan, to the medical examiner's office, right?
As a possibility, yes.
As a possibility. And you're aware that your other subordinate, Trooper Proctor, according to certain information he had gotten from first responders, also believed that a physical altercation was possible, right? As well.
It was possible, yes.
Okay. And you also knew that the house would be a normal location to have other individuals who might have been involved in that physical altercation.
Objection.
Can you answer that, Detective Lieutenant?
An altercation could take place anywhere.
Exactly.
And people can often travel from the location of the altercation miles away to another location.
Or they could travel 30 feet outside as well, correct?
Yes.
Okay.
Yeah, I mean, he's going through the points here. Carmen Brown, thank you so much for the super chat. Sorry, I'm a bit behind. I had to prep my dog's raw food. But wouldn't this prove that Karen was home between, 12:38 and 5:08 a.m.? That does seem to suggest that. Yeah. So I don't quite understand what the purpose of all of that was, other than to just lay some baseline facts about where she was. Why we're getting that at this point in the trial, I don't quite know.
in the early morning hours of, well, let's say the hours following your Massachusetts State Police initiation or engagement in this investigation, you became aware of Brian Higgins, correct?
Yes,
That name was bantied about as a potential witness in the investigation, correct?
yes,
And you're aware that Brian Higgins indicated that he saw a tall, dark-haired man enter the home after he arrived, correct?
I'm not aware of that.
And the reason you're not aware of it, Lieutenant Tully, is because nobody bothered to interview Brian Higgins until February 10th, right?
Objection.
So in that form, that's been sustained. Ask it differently.
Yeah,
When
more
was Brian
argument.
Higgins first interviewed?
February 7th?
7th, 10th?
To-
Yeah, in February, not January 29th, certainly.
Correct.
Although he was known to be inside the house, correct?
Yes,
So had you known that, had you had the information, for instance, that Brian Higgins admitted to having seen a tall, dark-haired man walk in the house, that might have changed the complexion of your investigation at that time.
Objection.
Can you answer that, Detective Lieutenant?
in the off chance that Mr. Higgins presumably had said something like that, I would certainly need more information describing this person. I would ask a series of questions to narrow it down to make sure that this person was John O'Keefe.
Right, exactly. That would just be a normal part of the investigation. You just take evidence A and link it to evidence B to evidence C. That would be the normal way to do the investigation.
We would normally follow the evidence, correct?
But in point of fact, nobody did seek a warrant to go inside the house, correct?
Correct.
Nobody did seek to have a forensic team go inside the house and look,
Correct.
and nobody asked for consent.
Correct.
I want to ask you about the
And the thing is, like that, these points of contention that Alan Jackson is bringing up right now have less to do with Detective Tully doing a poor job and more to do with like pointing that back to Trooper Proctor. Because remember, Trooper Proctor yesterday said, you know, he agreed he didn't really talk to Brian Higgins. He had an interview with him like so many days later in February. It may have been February 7th, but it may have been like February 4th or something like that. It was relatively early in February, but still like a maybe up to a week after the incident. So that and then he didn't look into his phone and didn't there are so many issues here with that. But you know, also after that information would have come to light, when did he actually say about a tall, dark figure? I can't remember if that came out in the interview with Trooper Proctor or if that came out later on with in his testimony in one of the hearings, Higgins' testimony in one of the hearings. I can't remember, but at some point that did come out. So the fact that he's saying here that Tully's saying, you know, yeah, I would need to know more information from that. I would ask more questions about that. That does seem sincere. Like that does seem like he's being pretty straightforward about that. Maybe he's just better at testifying than other officers that we've seen. Yeah.
Sallyport video, if I could. Did you obtain a copy of any video surveillance footage from Canton Police Department?
Yes.
Okay. If you can, tell me which footage you obtained and where. And there's several videos, Lieutenant, and it can be confusing. So if you could be as detailed as possible, explain what footage you gathered and when you gathered it.
Most recently, and the date escapes me, but it's within the last couple of months, I had contacted Chief Helena Rafferty of the Canton Police Department and asked her to burn another copy or create another copy of the Sallyport video during a certain time period on January 29th to ensure that the video that we had received previously was all of the records responsive to that request.
And you found out that the video that you received earlier was not, in fact, completely responsive because there was a video left out, right?
I didn't do a one-to-one comparison. I just had made the request.
Ultimately, you did receive a video of the interior of Sallyport, correct?
Yes.
And can you tell me, did you look at that? Did you review that video?
Quickly, not the whole thing.
Okay. Was there anything of note about that interior video? By the way, let me ask you another question, Lieutenant Tully, just to clarify. There's a very grainy, dark, almost black of the interior, correct? You've seen that one?
Yes,
Or excerpts of it?
yes.
And that video is missing some pretty significant time frames throughout the video?
I didn't review the whole thing, but I'm aware of that video existing.
Fair enough. Then there's another video that's pretty clear, right?
Yes,
Okay, I'm asking you about the clear video. Did you make any note about anything unusual about that video?
no. But again, I didn't really review it.
You didn't review it with any detail?
Correct.
Did you make a note that that video was inverted?
I did not.
Did you make a note about the timestamp on the video either being correct and properly positioned or inverted?
No.
Did you give that video to Trooper Proctor?
I believe I gave it to Sergeant Buchanan.
Sergeant Buchanan? And then what did Sergeant Buchanan do with it?
Reviewed it.
Okay. Is that somehow uploaded onto the Massachusetts State Police computer system somehow for safekeeping?
No, we'll hold it within the DA's office on that server. You know, it's not touching the MSP.
Okay, so it is uploaded on some sort of server.
We will memorialize it somewhere, yes.
Did Chief Rafferty give it to you on a thumb drive or a disk, or how was it physically provided?
I don't know. I didn't receive it. She dropped it off at the office. I remember a thumb drive.
You remember a thumb drive, all right. And then it's uploaded onto the system, and the case officer would have access to that system.
Yes,
Okay. And in this case, that would be Trooper Proctor.
yes.
Did you notify Trooper Proctor, when I say immediately, reasonably quickly, after you received, or after you got notice that the video had been dropped off by Chief Rafferty?
I informed Sergeant Buchanan.
Okay, and do you know, as you sit here, you may not, as you sit here, do you know if Sergeant Buchanan reasonably quickly informed Trooper Proctor that that video existed?
I don't know when or where that notification was made.
As you sit here now, you are aware that Trooper Proctor is aware of that video and had access to it?
Yes.
Okay. Yesterday, there were
TJM, thanks so much for the super chat. The cops would have gotten away with it if it wasn't for those dastardly kids and their dog Scooby-Doo. Thank
There
you.
was some testimony about taillight pieces that were found at the location, correct?
Yes.
May I have just a moment, Your Honor?
Yes.
Your Honor, may I approach the court magistrate for a
Okay.
question?
Okay.
Evidence yesterday,
Okay. May take a minute.
entered into evidence yesterday. With the court's permission, I've asked for the evidence bags that were entered into evidence yesterday.
Okay. May
Okay.
take a minute.
So we can fast forward through that. There we go.
Before I get to the evidence bag, may I inquire? Thank you. Before I get to the evidence bag, Lieutenant Tully, one more, or maybe a couple of more questions about the Sally Port video. You indicated that you received additional video from Chief Rafferty once she dropped it off. You said within a couple of months.
Yeah. Additional that package. Yes.
Okay. What was the original Sally Port video that you received? In other words, what were you following up on?
What you had previously described as a grainy black-ish video.
Okay, and so just to be clear and close that loop, when did you receive that video, if you can tell us?
Which one? The grainy one?
The great one.
Earlier in the investigation.
A year ago, 2 years ago?
I don't recall.
Okay. Do you believe it was pretty early on in the investigation?
I don't recall.
Didn't he just said it
Do you
was
know
pretty
what
early
the
in
mechanism was
investigation?
that you received that one? If Chief Rafferty is the one that gave over the clear video, how did you get the grainy video?
I don't know.
Was it you that received it, or do you believe that you commissioned Trooper Proctor to go get that video?
It would have been a task for Sergeant Buchanan or Trooper Proctor or someone else from the unit.
So the reason you don't know is because you didn't personally do it.
Correct.
Yesterday, you testified that it's obviously your responsibility as not just the chief of the unit, but as the evidence officer to maintain and protect the integrity of the physical evidence that's found under your supervision, correct?
Yes.
You indicated that you took photographs of the items that were recovered on that initial search. and you took those photographs in place where they were found, correct?
Yes.
With the exception of one of the photos, you indicated that it had been moved by a shovel, and then you instructed the individual put it back down where it was found, and then that's the point at which you photographed it, correct?
Yes.
You took an establishing shot, then a closer shot, and then I think even a third close-up shot, correct?
Yes.
And you indicated pretty clearly yesterday what the evidence that you found at the scene was a red plastic taillight piece that was recovered first, then 3 feet or so to the south of that, the shoe was recovered, and then 1 to 2 feet south of that, another red plastic piece, and then a clear plastic piece next to that, correct?
Yeah, you get the last two inverted. It's clear, then red. But
Inversion, it's becoming a theme. Sorry about that. So it's a clear piece,
So I'm going to strike that comment.
clear piece, and then a red piece next to the clear piece.
yes.
3 pieces of plastic in total and a shoe.
No, there was, with the clear piece, there was 2 pieces with it. So clear plastic, multiple pieces of the clear plastic.
Okay, so yesterday when we saw the photographs that you testified to, there was 1 piece of clear plastic that was photographed, right?
2.
Didn't the photograph have 1 sort of arc-shaped clear piece of plastic that you described as having the, did you say dimples or stippling?
Yes, I think I said dimples.
Okay. What was the second photo?
There's the next photo that was displayed was the second piece of clear plastic taillight.
So in fact, that would be 4 pieces of plastic.
Yes.
Okay. But yesterday you testified that you found 3 pieces of plastic, and in your report, you reported that you found 3 pieces of plastic, correct?
I didn't number the piece of plastic, if I recall my report correctly. I said we found clear plastic. And as I displayed out of the bag, there was 2 pieces of clear plastic that we,
But there was only a photograph of 1,
no, there wasn't.
and your report says 3 total pieces of plastic, doesn't it?
No.
Let's take a look.
Do you have your report with you, Detective Lieutenant?
Not that one, Your Honor.
Okay.
All right. So is this another report that is wrong? TGM, thanks so much for the super chat. I'd like to make you a custom leather legal pad cover with your logo on it. Also custom cowboy hats. I do want to make you a gift. Thank you so much. That's
Let me have
kind
just
of
one
you.
moment.
Sure.
Very, very kind of you. Honest Mike. No, it says backwards 3, not 3. That's funny. Debbie Faison Cook, did you remember to get a PO box set up? So far I haven't. I'm going to see if I can get one today, actually.
Your Honor, is it possible that we can take our recess so I don't waste the jurors' time? I can use my time wisely.
Sure. Sure.
All right, jurors, we'll take our morning recess.
All rise for the court, please.
So we're about 20 minutes behind here. We'll probably get right caught up to live. There we go. We'll get some questions here now. Okay. Baz 80s question. If it's a mistrial, wait, here we go. If it's a mistrial, do they redo grand jury phase? If they do, are these testimonies used to decide if it's a good case? Does that make sense? They wouldn't need to redo the grand jury hearings because they've already gotten an indictment. A mistrial would not be challenging the indictment. It would be challenging a potential guilty or not guilty verdict. So what they would do is they would just go to potentially a second trial. That's assuming, of course, the prosecution decides to bring another trial. L. Borate, in your hashtag not legal advice, do you think it was reasonable to get a search warrant based on what you know? I think that there is enough evidence there that they would have come across at some point to at least try to get a search warrant. But hey, other folks might have more expertise in this area and have a different opinion. Baz 80s. Sorry to bombard, but do you think YouTube, et cetera, is helping the prosecution? They keep swerving to cover things brought up like the shoe sole color, the way Lally is asking questions, et cetera. I don't know. I don't think that there's anything that YouTube is doing for any of that. I don't know. Maybe not, but I haven't seen anything that suggests that. Paula Shamek, would you be able to go over military/police ranks, sergeant, lieutenant, et cetera? What's the order? So I am not the most experienced person, and to my understanding, I think that it's actually different between military and police. Like for example, in the U.S. military, sergeant is usually a non-commissioned officer. That's somebody who has started off as an enlisted person. Lieutenant is like the lowest level officer. So like second lieutenant, first lieutenant, captain, major, lieutenant colonel, colonel, general. So like that I'm familiar with because that's relevant to my life. But like a sergeant, basically what I can tell you in the military is that is on the enlisted side as opposed to the officer side. And where like what all of the rankings are on that side, I don't quite know so much about in detail. I'm sure at some point I'll learn it. I'm slowly learning military stuff, even though I've been married to the military for a number of years now. But anyway, oh, and also it can be different between Army and Navy, of course. Right, because L Borate points out, 03 in Navy is a lieutenant, so third level officer 03. Anyway, so yeah, and captain is very different in the Navy. Like captain is, I think that's like general level, or is it colonel level? I don't know. I can't remember, but it's not the same as a captain in like the Army, for example. So anyway, it's different according to the branch even. So, but when it comes to the police, all what I understand is a sergeant is someone who has a leadership role in within the police station or the department. That's basically what I know at this point. So yeah. So I'm sorry I can't give much more information on that. Martin K, Navy captain, is colonel in the Army, I believe. Yeah, that sounds about right. So okay, yeah. So some information. Basically, sergeant is someone who has a leadership role in the police. Stephen Horton, question: what number witness are we up to, and how many are on Lally's list? At this rate, I'd be shocked if he didn't call every last one of them. So we are on number 58. Detective Lieutenant Brian Tully is number 58, and I think there's like 70 something or 80 something total. So I don't think we're gonna be calling all of them with the prosecution. I don't know, maybe not. Sarah J.H. Legalbytes, question: why does Lally keep doing this? He continues to ask witnesses to opine on things they're not experts in, IT, medical, etc. Why? Maybe because the actual experts that he is going to be testifying or calling to testify are not going to be able to give the same testimony that he's hoping that they can give. That is usually the assumption that I have based on my experience. But I don't know, maybe he's just trying to get it from as many people as possible. That also could be it. Veronica B, question: can Yannetti address the stuff Proctor told the jury about him? That if the judge had decided to just allow all of that in, that would have been a remedy, is to basically be able to cross-examine on that or add in more context from the defense. But the judge did properly come back and sustain the defense's objection and strike all of that and instructed the jury to disregard all of that. So that is the first remedy that we would like to see in that kind of a case. Lackluster, Legalbytes, do you think KR will take the stand? I don't think so. I really don't think so. Not at this point. I don't think she needs to. Janet G, Legalbytes, question: so basically the broken tail light is all they have to pin this on Karen Reed? I don't know. I mean, I am taking this case in the same way that the jury is, that, a lot of you guys are. I don't have as much intimate knowledge behind the scenes about the evidence that is out there. So from what we've seen so far, that seems to be the case. but maybe there's more. There could very well be more that I don't.
Sure, go right ahead.
Lieutenant Tully,
Whoop. Okay, they're gonna get into cross-examination, but let's get these questions first. But yeah, there might be more evidence that I'm unaware of, and we'll see it when it comes. Let's see, Josephina Soderholm. Question, Legalbytes, can you talk about Kay's blood alcohol test? Was that really legally obtained? Legally obtained? Yeah, I think so. There was a valid purpose for the hospital to be taking it. She was section 12, right? That's the term in Massachusetts for it. And so part of that sort of evaluation treatment is to take a blood test to find out what's in her blood, to see if there's something in her blood that's poisoning her, that is making her act a little bit different, right? That's affecting her brain in some way. So, that being legally obtained is one thing, but can we draw the conclusions that the prosecution is asking the jury to draw from that is another question, because there's a lot of math, there's a lot of calculations, there are a number of assumptions that have to be made in order to reach the conclusion that their expert is saying you've got to reach, or at least to the conclusion that he got to. So, yeah, legally obtained though, probably. Jonathan Willig. Since I'm dozing off during this direct, Alita, have you watched all this direct contempt / motion to recuse ex parte drama in the YSL trial in Georgia? I'm aware of it. If I have time, I would love to talk about it, but we will see. There's a number of plates in the air between this trial and then getting ready to travel back home overseas. Mike Olson, Legalbytes, has the U.S. judicial system always had these crazy cases going on, but now with cameras, it's more in the open, or is the trial getting more juicy because of the cameras? That is a very good question. And I'm sure that a whole debate could be had over that subject. For me personally, I think that these trials have been happening for a long time, even before there were cameras in the courtroom. I mean, that's what the musical Chicago is based on, right? There's a whole drama around trials. Given like the reason why I kind of call these defense attorneys in this case like razzle dazzle, that comes from that musical. There's a whole song, give them the old razzle dazzle them, and it's talking about the drama of trial and the reporters that are in the room that are writing these salacious stories about this courtroom drama. All of that comes from the fact that there was a market for it then. There always has been a market for these kind of crazy trials, these dramas that get played out in courtrooms. I really think that this is, it kind of just sort of, there's a big piece here that really comes from human psychology and our need to tell stories and our need to understand the world around us and the crazy things that happen. And the craziest things that happen very often end up getting played out in a courtroom, especially a criminal courtroom. So the fact that there are cameras in the courtroom, I think has an amplifying effect of this, so that it has more of a reach to more people. But I think that it hasn't created that interest out of nowhere. I think that interest has existed for a very, very long time. And it really comes from a very deep human interest that we all have. That's just deep in our DNA. Cat Love Dreaming Peach. Alita, have you ever heard or ever seen a bottom of a ninth inning stretch win in a case that seems so heavily leaning towards the defense? It's possible. It's possible. Anything is possible, right? I mean, we are still in the prosecution's case in chief. Larry Huffin question, how can they claim they know that's Karen's car by the timing when there's literally no way to prove what or whose black blob of a car that is? And that's why I said like the value of the surveillance footage is in corroborating some better evidence elsewhere. Those cell towers may be doing it, that they might do it. We'll see how things look at the end of cross-examination, right? Because that's where it really gets tested. But so far it's like, I would have preferred to use something like, maybe the cell towers, or as I said before, the infotainment system from her car. And then you use something that is less precise and a little more fuzzy, like the surveillance footage. KJ Height question, doesn't tracking a phone have to do with them being on or not on airplane mode. Well, hey, being on airplane mode apparently can impact that, though. But also switching a phone off to airplane mode can also indicate something about the mindset of the person who has that phone. That came up in the Caitlin Armstrong trial too, out of Austin, Texas, where she was, driving around stalking the victim from what it looked like. And at one point, when the victim returned home, when the defendant was like en route and basically following the victim, at one point she turns off her cell phone, is seemingly knowing that her phone is probably going to be tracking her, and then goes and follows along the route and goes to the victim's residence, and then or where she was staying, I rather. And then 30 minutes afterwards, when she's driven to another place and she's tossed the ammunition that she used in the gun that she used to kill the victim, then she turns on her phone again from airplane mode. So that can also indicate a lot of information, but it doesn't require a phone to be on or off airplane mode to get valuable information. Sometimes the timing of that kind of stuff too can also say something. Sheena Ford, Legalbytes, how is the judge not admonishing Lally for time wasting? Can she not say, get to the point? Not on something like this. She's going to want to allow him to make his points, make his case, with the evidence that's provided. Like this, it's very boring to me. It feels relatively pointless when there are ways of doing this that can make it feel like there is more of a point to it. But that evidence coming in realistically is fine. Like the judge can't really tell him, no, you can't present this for that purpose. The Lucian question, regarding the demonstrative maps with eligible markers, could the prosecution say draw small circles around the icons the officer placed, or would it have to be redone by the witness? No, I mean the attorney can do it at the direction of the witness, right? You can get up on a board, draw a big circle on a map, and say, like before doing it, saying, is this the location that you're talking about? Okay, right here. You can definitely do that. And actually that can kind of trigger the attention of the jury back again if they're getting lulled to sleep at that point too. Seeing movement in the courtroom, seeing things happen, that is all very helpful to draw the attention of the jury back in again as well. Baz 80s question, what in your opinion is Lally's strategy here? Can you see what the point he's trying to make, or has he lost the plot? There was a while that it was getting pretty difficult to see what his point was, but it seems that they were really trying to show the jury what her route was, kind of placing her on the map at various points in time, just to kind of set a foundational kind of a story, I suppose, which is fine. Okay. Moving on down, we've got a number of other questions here. Sheena Ford, Legalbytes, maybe Lally is just trying to prove he got an expert to show he looked into the cell phone towers. I mean, yeah, that they did in fact look into that. Okay, sure. Mike Olson, Legalbytes, but the trooper above Proctor, the epidermis of the skin dude, got to answer as if he was an expert. Where do they draw the line of what one can testify to or not? Judges also make mistakes on these things sometimes. And it depends on, what area of expertise we're talking about. If it's like medical causation, that's going to get pretty quickly sustained. An objection on that is going to be pretty quickly sustained because it's pretty clear just how far the cops can go when it comes to medical testimony. Emma Lisa 4, question, if Karen is found not guilty, what, if anything, do you think will happen afterwards? I mean, if she's found not guilty, maybe she can go on a press tour. She can try to recoup some funds in some various ways with publicity and things like that. Maybe there can be some lawsuits over her private information getting disclosed in the way that it was. Some civil lawsuits. There might also still be civil lawsuits from the O'Keefe family against Karen Reed. That's another thing that she would probably have on the horizon at some point. Christopher Lambert, question, was he wearing his jacket in the video of him leaving the bar? If so, did they ever find the jacket? He was just wearing that sweatshirt. And that was the reason why the prosecution was pointing that out as often as possible at Waterfall Bar and Grill, basically to say the jacket was never inside the house. That's what he was pointing out there. But as far as the police knew early on in the investigation, there is a valid question of, did they know that? How did they know that? You know, had they reviewed the surveillance footage within 24 hours of this happening? You know, valid questions by the defense here. Link Journey, but did you both reach for the gun? The gun, the gun, the gun, the gun. Yeah. Angry Grape Stoner, I missed this morning and the law examination yesterday. What did I miss? That's a little bit too big of a question for me to be able to answer at this moment. But some information basically with Detective Tully. As for yesterday, you can check the recap. It is out, so definitely check it out. There's even timestamps if all you want to see is what I say about Detective Lieutenant Tully. Definitely check it out. It's right here on this channel, so super easy to find. Latest upload. Okay, I think that's all the questions. We are caught up on that. We're a little bit behind on this testimony now, but that's fine. We'll get caught up eventually.
We were talking just before the break about
Here.
time.
Sure, go right ahead.
Lieutenant Tully, we were talking just before the break about the search on January 29th, 2022. Obviously, it's important to be accurate in terms of the memorialization of things that are found of note during a search, correct?
Yes.
And the way that you normally would memorialize something like that would be in a police report, correct?
That's one method. Yes.
You might have personal handwritten notes
I
that
might.
would attend a search, correct?
Yes.
You might videotape part of it or all of it,
I could.
and then you could photo document it as well.
Yes.
But ultimately, the circumstances surrounding how something was found or what was found at the time is best done in a memorialization in a police report, correct?
That is one method. Yes.
And that is the official record of what was done at the time and who did it, correct?
Yes.
And you did, in fact, draft a police report as it pertains to the search that was done by the CERT team on January 29th, 2022.
Yes.
Mayor Pro Tem?
Yes.
Tell me if that looks familiar to you.
It does.
Is that your report that you utilized? Is that the report that you wrote, rather not utilized? Is that the report that you wrote documenting the search that was conducted that you've testified to in front of this jury?
Yes.
What's the date of that report?
February 10th, 2021, which was a typo, should be February 2022.
Okay, so February 10th, 2022 was the date that you memorialized the information about the search, correct?
Yes.
Obviously, that was much, much closer in time than today, correct?
Yes.
Or yesterday, correct?
Correct.
If you turn to paragraph 3, could you review that paragraph and tell me, after you review it, if that refreshes your recollection about exactly what you indicated was found by you and the CERT team on January 29th, 2022?
My recollection of what was located remains the same. I do see that the report states that it was a piece of clear plastic.
Okay, so in fact, your report says that at approximately 17:45 hours, which is what time?
5:45 p.m.
The CERT team located, quote, a piece of red plastic, correct?
Yes.
And then it goes on to say it was consistent with brake-like material from a motor vehicle, right?
Yes.
Then if you look down a couple of other sentences, you talk about the shoe that was then recovered, correct?
Yes.
Then if you look at the second to the last sentence, a few feet south from the sneaker, a piece of clear plastic consistent with clear lens of a motor vehicle was located, correct?
Yeah, the quote is a second piece of red plastic. Yes.
Well, actually, the sentence before that, sentence just above that, starting with a few feet south.
Yes.
It reads, a few feet south from the sneaker, a piece of clear plastic.
That's not what it says. Would you like me to read it?
Oh, I'm reading it. Sure, read it.
Okay. The sentence is several feet south of the clear plastic.
Lieutenant Tully.
Sorry.
Sentence above that. Before that.
A few feet south of the sneaker, a piece of clear plastic consistent with clear lens of a motor vehicle was located.
Right. So in your lexicon, a piece means singular, does it not?
Yes,
If you meant pieces, you would have written pieces. You're educated, correct?
allegedly.
So clearly, from this report that was memorialized on February 10th, you indicated that a piece of clear plastic was located consistent with clear lens from a motor vehicle, right?
That's what it says.
Okay. Then, well, it's not just what it says, it's what you wrote.
Correct.
Right. Then the next sentence, which is the sentence you were about to read, go ahead and read that for me as well.
Several feet south of the clear plastic, a second piece of red plastic was located.
Okay. Simple math. According to your report on February 10th, a piece of red plastic was found first. Then a piece of clear plastic was found. Then a piece of red plastic was found thereafter,
Yeah.
correct? According to that report.
Yes.
Then you go on in the following paragraph to reiterate, just to clear up any doubt about what was found. And the last sentence reads, the sneaker and 3 pieces of plastic were secured as evidence, correct?
Objection.
See, overruled, I don't know. What's the objection?
Form.
No, I'll allow it.
Is that what it says?
Yes.
Okay. Then yesterday, you were asked to open these 2 evidence envelopes, correct? The evidence bags.
Could I take a look?
Oh, of course, yes. May I approach you on that?
Yes.
Sorry. 570, 571.
Oh, I thought they had said it was like 5 or 6 pieces of plastic were found on this day. So if it was only 3, according to the
Those are the
report,
bags that you opened yesterday,
it's
correct?
interesting.
Yes.
You indicated yesterday in front of the jury, you didn't indicate, you pulled out 2 pieces of clear plastic, did you not?
I did.
That was in bag, I want to say that was in bag 570. Why don't we do this? Can you please open, with the court's permission, can you please open bag 570? I'm sorry, exhibit 570 in that bag, and just look inside.
I didn't bring gloves with me, Your Honor.
I
Is
think
there-
there might be some on the stand.
Oh,
They're
there.
right
thank you,
next to you, sir.
Attorney Jackson, could you just repeat your request again, make sure I have it correct?
Of course, Lieutenant. Let's start with 570.
Okay.
I don't remember which one it is, so if you could just open it and look inside and describe for us which items are inside that bag.
So 570, the description is pieces of red, hard plastic taillight cover contained inside this bag.
Look down in there and tell me, do you see red plastic pieces?
Yes.
Okay. Yesterday, you pulled out 2 pieces and indicated that was what was contained in the bag, correct?
Correct.
Take another closer look.
As I take a closer look, there are 2 pieces and there is a very small fragment that remains in the bag.
Can you pull that fragment out as well? Can you show that to the jury?
Oh, that's teeny tiny.
Okay, you can go ahead and replace that. So in total, Lieutenant Tully, how many pieces of red plastic are in that evidence bag?
As we sit here today, there are 3.
Thank you. Go ahead and close that. And we can open up the second bag. I'll go ahead, with the court's permission, may I approach?
Yes.
Thank you. Your Honor, may I?
Yes.
If you wouldn't mind, the next bag is exhibit 571, is that right?
Yes.
Could you please open that and let's go through the same process? Just look inside and tell us what you see.
Inside 571, there are 2 pieces of clear plastic.
You can go and replace those. Thank you, Lieutenant. Those two bags are supposed to represent what was found by the CERT team on January 29th, 2022, correct?
Yes.
There's 5 pieces of plastic, 3 red, 2 clear, correct?
As we sit here today, yes.
My question, Lieutenant Tully, is where did the other pieces of plastic come from?
Be more specific? Which pieces?
Where did the extra 2 pieces of plastic come from in those evidence bags?
Well, it appears to me that small fragment I pulled out may have potentially come from the larger piece. The
I
other,
think that, just to
In other
clear that
words-
up, you believe, as you sit here, that smaller piece was broken off from one of the larger pieces,
again, I'm making a
Oh,
big assumption here at your request.
okay?
So yeah, that's what it appears to me by looking in the bag.
And by the way, Lieutenant, this isn't a trick question. I'm not asking you to assume anything. You were there and you recovered the pieces and you described recovering 3 items of evidence, correct?
No,
Didn't you just read in your report? I'll read it again, last sentence, the sneaker and 3 pieces of plastic were secured as evidence.
that's
You wrote
4.
that.
That's 4.
Sorry, I said items of evidence, items of plastic. Let's leave the sneaker out of our discussion for the time being.
so what Jackson is getting at here is that teeny tiny piece that he just pulled out of the bag, that may have been broken off of one of those bigger pieces, meaning that there's been some mishandling of this evidence. So there are 45 pieces of taillight, but like, how many of those 45 pieces were actually found on the ground at some point? I mean, there's questions already about that, particularly from the defense, but like, how much of this evidence has been handled properly? How much of this has been mishandled? There already are questions going into today that I was hoping that Detective Lieutenant Tully could answer about the chain of custody of this evidence. But if now, and this was offered up by this witness, this wasn't like dragged out of him by Jackson. He just asked him, where did that extra piece come from? Or where did the extra 2 pieces from the other bag come from? And the response that Detective Tully offered was, well, maybe it broke off of one of those bigger pieces, which calls into question how this evidence is being handled. If pieces are being just broken off because of the way that it's being transported, or the way that it's it's just, how is this happening? How is this happening? This is a big problem.
You were the one that conducted the search, correct?
The CERT team conducted the search. I was
You
present.
memorialized the search.
Yes.
You were there photographing the things that were covered in the search,
Yes.
and ultimately you were responsible for bagging those items up, correct?
Yes.
There are 5 items in that bag, or in those 2 bags, right? Just the plastic.
Correct.
And yet your report very clearly says there were 3 items of plastic evidence recovered at the scene, correct?
Yes.
So my question, once again, is where did the extra 2 items come from? The pieces of plastic.
Well, as memorialized on the bag, it says pieces of clear plastic. So I'll take the hit that my report does not properly memorialize it. But I would argue that the handwritten notes on the bag that are contemporaneous to the collection of the evidence would be more accurate, as is in my memory of 2 clear plastic things being collected. Now, as to the third piece, again, I'm making an assumption, but it appears that that is a small piece that was separated from the other 2 pieces.
You don't know that that's small.
So, regardless of which one is right, the handwritten notes that Detective Tully says the handwritten notes that were taken contemporaneously on the bag itself as they were bagging it, that's contemporaneous with the report. That's inconsistent with the report. The report says there were 3 pieces of taillight. The evidence bags show there were 4 pieces of taillight. Obviously, there is a 5th piece of this taillight here now. One of the problems with this moment right here for the prosecution is that, once again, there is a bit of this evidence that was not properly revealed, that was problematic for this case, not properly revealed by the prosecution. The jury is learning about this for the first time from the defense. how many times I have lost count, how many times this has happened in this particular trial where the prosecution presents evidence here, which actually was quite boring, right? It was quite boring bringing in these taillight pieces to show the jury taillight piece, right? Like who was even really paying close attention at that point, because we've seen so many taillight pieces in this trial so far. But like now we're hearing, okay, but there was another one in the bag. There was another one in the bag, and someone should have known. I mean, the defense obviously knew about it. So why didn't the prosecution then say, okay, now look, there is another piece in the bag here, right? Yes, there is. What do you think happened here? Like, what's the story with this little baby piece, baby tail light? What do you think, or what do you posit may have happened? Then, it doesn't look good. It still doesn't look good, but at least it's coming from the prosecution to say, something may have happened with this one right here, is so anyway, so that's already a problem, is once again feeling like we're getting the true story from the defense. And then on top of that, then there's this issue of the inconsistency between the bags, what's handwritten on the bags, and then what is actually in the report. The inconsistency, it doesn't matter which one is correct to the defense. That doesn't matter. What matters is the inconsistency calling into question whether or not the jury can rely on what the prosecution is putting in front of them. Because remember, the prosecution has the burden here of proving this case. It doesn't matter necessarily for the defense to disprove that the jury can rely on this stuff, but the prosecution has to present this in a way to prove affirmatively that the jury can rely on this stuff. So if there's any kind of a question, there's any kind of an ambiguity, that goes against the prosecution. Ambiguity ends up in favor of the defense because they're not the ones with the burden. Muddy middle goes to the defense, so to speak. So big problem for the prosecution with this stuff, especially if the jury is looking at this and already kind of having some questions about a lot of this stuff.
Small piece separated from
Sorry, going back a little bit.
You don't know that small piece separated from the other two by being broken off, do you?
No, I don't.
Just a guess on your part, right?
It's a guess. The bags were, out of our custody at the crime lab for a period of time. They had done an analysis. We did an evidence review with yourself, and the defense counsel on December 1st of last year, where we pulled all the evidence out. It was memorialized by your investigator, and it was put back in the bags.
You didn't see our investigator snapping pieces off the plastic, right?
He did not.
So he's trying to say that, well, maybe it was the defense's investigator that did this because, this was out of our custody, out of our control. And, there was record keeping of that. But that's why Jackson then asks, well, I mean, you didn't see our investigator breaking this piece off. Well, no, I did not. Or no, he did not. So like, okay, he's trying to kind of cast some shade over there on the other side to say, well, maybe it was your side that did this. But man.
I want to shift gears for a second, Lieutenant, and talk a little bit about the cell records that you testified to. Specifically the Verizon call records that you testified about. During your training, the 200 plus hours of training that you had, you've learned how to read Verizon records to determine cell towers that are used in your investigation, correct?
Yes.
You were also taught how to read Verizon call records to determine the sector or the side that a cell tower is pinging, for lack of a better word, called a cell face, correct?
Yes.
All right. One of the May I approach?
Yes.
Thank you. One of the documents that you rely on pretty heavily is ultimately it's a call record that gives you certain information, provided by whoever the carrier is, Verizon, AT&T, T-Mobile, whoever, right?
Yes,
Do you recognize the document that's in front of you or the portion of the call record that's in front of you?
it appears to be a portion from the call detail records we referenced earlier.
Okay. My questions about this are relatively simple. There is a sector number that provides information that describes the directionality, if you will, of the target phone number, which part of the cell tower that target phone number or that target device was facing, correct?
Yes,
In your maps, did you include any of the cell face data about which portion of the cell tower was pinging vis-a-vis the phone that was being tracked?
no. Can I explain why I made that decision?
Please do.
When the trouble with depicting and making exhibits when relative to cell phone records is you don't want to make the map too complicated. So as I describe it to the jury, I want to make sure that the record is clear. Now, I don't typically will use the sector as part of my maps. I would argue that it gives greater deference to the defendant because the phone could be anywhere within a 360-degree area of the antenna opposed to a narrower 120-degree area around that antenna. So for the purposes of making a clear depiction, I typically will not use sector unless it's absolutely important to show that a handset was in a specific location.
And so you did not include the sector information on the maps that you provided, both to Mr. Lally and that you showed to the jurors and provided us, correct?
Yes, whereas relative to the CSLI ones, yes.
So in point of fact, according to the map at least, wherever that little triangle is, that red triangle that you use to denote the cell tower or the antenna, the responsive phone, the device, could be anywhere on a 360-degree azimuth from that antenna, correct?
Yes.
I want to ask you about the one map that was related to 5:20 a.m. to 5:37 a.m. You remember that?
Not off the top of my head.
Okay. There were several maps shown. Can I approach?
Yes.
That's a copy of a page of an exhibit that's already been marked and entered into evidence. You recognize that?
Yes.
And that's a copy of your map that you did dealing with ENBID 57021, correct?
Yes.
And the time frame was 5:20 a.m. to 5:37 a.m. Is that right?
Yes.
All right. And by the way, do you know what ENBID stands for?
No, that's why the legend key is helpful. It's node is the NB, but I'm unsure on the E.
Evolved Node B Identifier, right?
Is that a question? Yeah, that's possible. Yes.
It is my question.
Okay.
Refresh your recollection. That's what it means.
I have to look at the key again, but that sounds right.
So an evolved, if that's what it stands for, an evolved Node B identifier, and then a series of numbers after that is simply sort of the proper name for a particular tower.
Correct.
No two towers have the same ENBID, correct?
Correct.
Okay. With regard to, and I'm just going to call it ID 57021. Do you see what appears to be, on your map, what appears to be the cell tower that is associated with that ID number, 57021?
Yes.
Okay. And there's one address that's denoted on your map, correct? Is that 34 Fairview?
No, there's multiple.
Okay. What are the other addresses that you noted on your map?
One Meadows Ave and Waterfall Bar and Grill.
Okay. May I approach you on that?
Yes.
If I could hand you another map, does that appear to be a Google map?
Yes.
Does that generally track the map that you created, the darker map you created? Meaning it's the same basic scale?
It is not the same scale.
How much different is that scale?
The one you handed me is a zoomed in version of the map I created.
Okay. You recognize it as being relative, true and accurate reflection of a Google map that's just zoomed in a little bit on the same basic area?
As you just described, it appears to be Google Map
Okay.
creation.
And you see two addresses that are denoted on that Google map?
Yes.
What are those two addresses?
34 Fairview Road and 12 Country Lane.
And as you look at that Google map with both of those, given your experience with both of those addresses, do those appear to be denoted accurately on that Google map?
It does. I would note that you can't see the roads really on this map that you handed me.
Understood. I'm not going to ask you a question
It's
about
kind of it's a white blur, so it.
Okay. But does it look like that's where 34 Fairview is and that's where 12 Country Lane?
Yeah.
Okay. Then I'm going to ask you for the third item that's denoted on the map, and that is the cell tower 57021. Do you see that denoted on the map?
Yes.
Does that appear to be generally accurate in terms of the spatial location of where that cell tower is?
Yes.
Move for the admission of that item, that document.
Objection.
Okay, so fast forward while they.
Taking a look at that exhibit, would you agree that the cell tower 57021 is significantly closer to what's denoted as 12 Country Lane, the McCabe residence, physically as a crow flies, than it is to 34 Fairview?
I would not characterize it as significant.
How would you characterize it?
That it is closer.
Okay. May I publish, Sean?
Okay.
Take a look. Just a second. Take a look at the upper portion, upper right portion of the map that I just highlighted. What does that denote?
The cell tower that we previously mentioned, 57021.
Okay. And then,
Oh, look, this is a map that we can see the colors, where we can see the little symbols that we're supposed to be looking at. What a concept.
there's a line it's a straight line from that cell tower down to this location. What is that location?
It's denoted on this exhibit as 34 Fairview Road.
Okay. And do you see a legend indicating scale? How far that is?
I see numbers and miles written on there.
Does that appear to be reflective of given your understanding and your experience with this location or these locations, does that appear to be a relatively accurate delineation of the distance between the cell tower and that location, and that address?
I don't know the distance between the cell tower and the address off the top of my head.
Would you agree that it's around 2 miles?
It's roughly 2 miles.
Okay. Then I'm going to ask you to take a look at the same proximity, cell tower on the top of the screen, and then the address at 12 Country Lane. Do you see those two items denoted on the map?
Yes.
And do you see the approximate distance between those two items?
See it on the map?
All right. And does it appear to you that the distance from 12 Country Lane looks like it's less than half the distance to 34 Fairview?
I wouldn't characterize it as appears to be less than half.
How would you characterize it?
My understanding of that area, I would say it's at least a mile between those two locations as the crow flies.
Okay, meaning between the cell tower and 12 Country Lane,
Yeah,
right?
Yes.
And it indicates approximately a mile, correct?
it does indicate that.
Okay. And the other location indicates approximately 2.4 miles, right?
It does indicate that.
All right. So would you agree that a mile is less than half of 2.4 miles?
I would agree a mile is less than half than 2.4.
Thank you. We can take that. You also noted that there were two cell towers much closer to 34. There are two cell towers much closer to 34 Fairview than the 57021, correct?
Yes.
And as a matter of fact, you already noted that for the jurors that say at 6 a.m. or 6:05 a.m. and thereafter, when it's clear that Ms. Reed was at 34 Fairview, she found the body of John O'Keefe, that her phone was relaying to those two towers bouncing back and forth, correct?
Yes.
Those two towers are 57171, correct? Sorry, I don't mean to test your memory like that. I can. May I approach?
Yes.
This is just his grand jury stuff, the same stuff that you should. I'm just going to give you that packet, Lieutenant. Like I said, it's not a memory test. If that helps refresh your recollection of the name of the two towers closest to 34 Fairview. Do you have that in mind?
Yes, sir.
Okay, so the two towers closest to 34 Fairview are 57171, correct?
Yes.
And 57286, is that right?
Yes.
And both of those towers picked up Miss Reed's signal at 12:33 a.m. and again after 6:03 a.m., correct?
You asked me about 12:33, so it's okay. I'm going to refer back in the exhibit,
Of course.
and that is correct. It hit the 57171.
And then after 6 a.m., it was also picking up, bouncing, I think you said bouncing back and forth between 57171 and 57286.
Yes.
Both of those towers were picking her up.
Yes.
Importantly, though, between 5:20 and 5:37 a.m., neither of those two towers ever picked up her phone or any signal from her phone, correct?
Correct.
So based on those facts, it's far more likely that Karen Reed was actually at Jennifer McCabe's and on her way to Jennifer McCabe's at and around 5 a.m. than going to 34 Fairview, correct?
Objection.
Sustained.
May I approach this to retrieve?
Sure.
I just want to make sure I didn't leave the mark.
Oh, I'm sorry. That goes with that, I believe. Oh, you handed me that. Here's the marked item.
Perfect. Make sure that stays there.
There were two other documents you had handed me previously that are not marked.
Okay. Thank you, Rod. I just want to touch very briefly on the ranging data, the RTT records. What does RTT stand for?
Depends on who you ask from Verizon, either range to tower or round trip time.
Have you ever heard real-time tool?
I have.
Okay, so that's the RTT has several acronyms, but real-time tool is one of them, correct?
Yes.
The
Really quick here. Sandy, thank you so much for the generous super chat. I know an accident reconstructionist, and he said that the taillight pieces should have been individually wrapped and placed in a box, not a bag, to minimize further fracturing. Their collection methods are a hot mess. It does seem like it, right? It's them just kind of like jingling around in this bag without any extra cushioning or anything like that. Definitely seems a little strange, especially now that there has been this introduction into the courtroom by a witness of the possibility that a small piece has actually broken off of it. It does feel like the physical evidence in this case has not really been managed very well at all. Starting, of course, from
Red Solo Cup, I fill you up.
and then going all the way to the current taillight piece being broken off. It's just throughout, whether it's Canton PD or the Massachusetts State Police. It seems like they're just kind of tossing the physical evidence in this case to the wind. It's definitely starting to feel that way. It's been feeling that way, but it just feels like it's getting more and more confirmed, right? Thanks again for the super chat, Sandy.
The RTT data is what you earlier described as a ranging data or access distance, correct?
I didn't use the term access distance. I know that Verizon may, but I said ranging.
So it's just in common vernacular, it's the distance from the tower or from the antenna to where the signal is going, correct?
Yes.
All right. May I approach one more time?
Yes.
Could you please review that and tell me if you recognize what's depicted on that document?
I recognize it to be one of the entries from the RTT report for the account we're talking about.
I'm sorry. And it's around 5:18 in the morning, correct?
Yes.
Okay. And you utilize this report or portions of this report, including this entry, to come up with your data, especially as it relates to ranging data, correct?
Yes.
Do you see the column on that document called cross duration sex, right? Procedure duration sex.
I do.
What does that mean?
That is the amount of time in which this communication occurred.
Okay. Am I correct in understanding that the length of time for the RTT event is calculated in seconds, correct?
It is.
All right. Do you see the row in the exhibit that indicates the time 5:18 a.m.?
Yes.
And do you see a column that's labeled procedure start time?
Yes.
And right next to it, there's a procedure end time, correct?
Yes.
Are those the start times and the end times that you earlier testified to in front of the jury about the event in question at 5:18 a.m. or thereabouts, the start of the interaction or the communication with the device and the end of the communication with the device?
Yes.
When you say communication with the device, what does that mean? What are you referring to?
It,
A phone call, a text, something?
we don't know. As I testified to, the ranging reports will create entries even unbeknownst to the user. So I have no information with this record before me about what the user was or was not doing with the phone.
But your testimony is that those two arcs that we saw, those respective arcs that we saw, your testimony is that this RTT data, in your view, establishes that she was on the device, not she, but the device was on the first arc at the start time, and it was on the second arc at the end time.
I'm going off the ranging that they give me.
Right. And then you created those two arcs. I'm just trying to make sure I understand what the definition of those two arcs are in your map.
The definition comes from the first distance and last distance, which is denoted on this exhibit you have in front of me here.
Okay, and the first distance is what?
0.82 miles.
Okay, and the second distance is, from memory, I think it's 0.97?
Correct.
All right. That's a difference of what? We do the math.
1.5 miles.
0.15 miles, correct?
Excuse me, yes.
Okay. And do you see the procedural duration column indicated on that document?
I do.
Okay. And the procedure duration column indicates 0, doesn't it?
Yes.
However, if we look very closely at the start time and the end time, they're not actually the same times, are they?
Correct.
There's a difference in those two times. Can you tell the jurors what that difference is?
It is 4 thousandths of a second.
0.004 seconds, correct?
Yes.
And you testified that you believe that the start and end distances for the RTT event in question indicate two different locations for that device. In other words, the start time, it was on the first arc. The end time, it was on the second arc. You don't know where on the arc, but somewhere on those two arcs.
Using the ranging data, I created a map,
I
and
understand.
that's what I did.
Okay, and so the device would have moved from the first arc to the second arc, correct?
Yes.
Right. You're familiar with, obviously, the formula to determine speed using distance and time, correct?
Yes.
All right. Can you calculate for us the speed that the device would have traveled to go from the first arc to the second arc over a distance of 0.15 miles in 4 thousandths of a second?
Not off the top of my head.
Okay. Let me see if I can help. So
Speed of
distance,
sound or light or something.
sorry, speed is calculated as distance divided by time, right?
Yes.
If you divide 0.15 miles by 4 thousandths of a second, you come up with 37.5 miles per second. Would you agree?
Objection.
Sustained.
Can you do the calculation in your head?
No, sir.
Do you need a calculator?
I would.
Your Honor, if
I'd like to see counsel at sidebar, please.
Yeah. There's going to be a question as to whether or not he's going to be allowed to use a calculator. What kind of a calculator is he going to use? How, what's going on with this device that you're about to put in front of him to make this calculation? So we're going to try to do some math here and trying to have him do math on the stand. There are going to be definitely some issues that they've got to clear up on sidebar. Absolutely appropriate use of sidebar here. Like, I like Jackson, I really do, but I agree with that call here.
Lieutenant Tully, do you happen to have your cell phone with you?
I thought you were going to ask the other question first with your numbers.
I can. Let me ask you, so you don't have to sit there with a cell phone in front of you, let me ask you if you would agree with this, that 0.15 divided by 0.004 is 37.5.
I'd have to write it out. I'm not sure. I'm sorry.
If you had a calculator in front of you, could you do it?
I could.
You don't have your cell phone with you.
I do not.
With the court's permission, I've got mine right here, I can turn it on, or my co-counsel has one.
How about, can you use Madam Court Reporter's cell phone and do that? She's closest.
Yes, Your Honor.
Thank you.
Okay,
Thank you, Madam Court Reporter.
Thank you, Your Honor.
there we go.
If you could divide 0.15 by 0.004,
Excuse me.
let me know what you come up with.
37.5.
So that would be, given the fact that the distance as calculated, as indicated on that record, the distance is 0.15 miles over the course of 0.004 seconds, right?
No, I would push back as to when the distance was being created. That's the first distance and last distance.
Correct. What you indicated was the cell phone or the device was on the first arc during the first time, and the start time, and on the second arc at the end time. All I'm asking is some basic math. So you would agree that if the calculation we just did, or you just did, is 0.15 miles divided by 4 thousandths of a second, that is 37.5 miles per second, to stay consistent, miles per second, correct?
Well, I don't agree with the premise of the question. So
You don't have to agree with the premise of the question. I'm asking you about the math.
Oh, the math is correct. Yes.
The math is correct, right? It's miles per second, correct?
Yes.
Based on that calculation. In order to get to miles per minute, you multiply it by 60, correct?
Yes,
Can you do that for me, please?
Madam Clerk.
Mark Smith, I think she went plaid. It's ludicrous.
The question again, sir. I'm sorry.
Yes. Multiplying 37.5 times 60 would give us miles per minute. What is that number?
2,250.
And if we wanted to go to miles per hour, which we're more familiar with, multiply it by 60 again. And what's that number?
1,035,000. Excuse me. Sorry. 135,000.
135,000 miles per hour, correct?
Yes.
So you would agree if the premise is moving from the arc, the first arc, moving 0.15 miles to the second arc over the course of 0.004 seconds, the device would have to be traveling 135,000 miles per hour, correct?
In your question, you said 1.5 miles travel. It's 0.15 miles. You corrected me. I'm going to throw it back at you, sir.
Fair enough, fair enough.
All right.
Okay. 0.15 miles over the course of 0.004 seconds, the device would have to be traveling 135,000 miles per hour. It's basic math, correct?
While I agree with that, I would push back. That's probably not what the record is indicating.
You would agree that that is physically impossible, correct?
For cell phone, yes.
Right.
It's ludicrous speed, right? Yeah, Mark Smith, I think she went plaid. Exactly. It is impossible for her to have traveled at ludicrous speed to be able to make it from there to there, unless she is an actual wizard and she is able to disapparate. How many movie references can we make in one sentence, right? So yeah, that's not gonna happen, even with the fastest of cars and planes, even, actually.
And you would also agree that since that's impossible, you're not suggesting to this jury that the device moved from arc 1 to arc 2 in 4 thousandths of a second. That can't be what you're suggesting.
I'm not suggesting that.
Okay. In fact, what actually makes more sense is that the signal was moving to and from the device at light speed, 186,000 miles per second.
It does. Radio
waves move at what?
speed of light.
Speed of light, 186,000 miles per second, right?
Yes.
Okay. If, as you indicated on direct examination, if that return signal, the bounce, is in any way refracted, meaning it takes a deviation, and it's not straight because of something like, I don't know, weather, precipitation, or snow, then it would take longer to get back to the intent, correct?
That's fair.
And that could be what's reflected in that map and the distance of the two arms. Isn't that correct?
That's not my experience with these records.
But you do agree that in fact the device, as you indicated earlier, moved from arc 1 to arc 2 from the start time to the end time. That's impossible.
No, I'm saying that the records reflect that the first time the distance was created, marked, and the second time the distance was marked, that's what's represented on the map.
Right, but you said that those are reflective of the start time and the end time, which is 0.004 of a second apart.
No, I don't know that's when these distances were created. It doesn't say start of procedure distance. It says first distance, last distance.
Actually, it says,
Fair enough, Quentin Smith. Good point.
see if I got the copy of what I just gave you. I don't. Fair approach?
Yes.
Procedure start time, 5:18 and 19 seconds, 0.154, right?
Yes.
Procedure end time, 5:18, 19 seconds, 0.158, right?
Yes.
That's the difference. May I approach one more time?
Yes.
That's the difference. And that's the 0.004 of a second difference, correct?
Yes.
And on direct examination, you said the start time and the end time are how you calculated the two different arcs,
No.
correct?
No.
Are you changing your testimony?
No, the map says first and last, as reflected in the record, first distance and last distance. So one could hold the map and this record next to each other and figure out how I determined those locations depicted on the map. It doesn't say start and end time. It says first and last.
Right. But you said that it was the beginning of the communication and the end of the communication, which are both reflected on that document, Lieutenant. The
Yes.
start time and the end time. I understand what you're saying about the distance. It's 0.15. Nobody's arguing about that. You're saying, you said on direct examination that the distance was a difference between what time the first arc occurred and what time the second arc occurred. And there was a distance between it. And your testimony was the device moved from the first arc to the second arc. You just said it, right?
I'm saying the device moved from the first arc to the second arc. Yes.
And it would be impossible to do that in 0.004 of a second, correct?
A cell phone. Yes.
You did one last issue, and I'm gonna deviate from the cell tower stuff. You got information during the course of your investigation that an eyewitness placed a Ford Edge in front of 34 Fairview in the early morning hours of January 29th, 2022, correct?
I'm familiar with that.
As the supervising investigator, by the way, you were familiar with the fact that the eyewitness placed that Ford Edge see if I can start that over. The eyewitness indicated that the Ford Edge was placed there sometime between 2:30 in the morning and 3:30 in the morning, correct?
I'm familiar with that.
All right. As the supervising investigator, did you do anything to investigate the circumstances of that Ford Edge being placed in front of 34 Fairview sometime between 2:30 and 3:30 in the morning?
Yes.
What did you do?
Well, we determined the veracity of that statement, and we want to make sure that the person who gave it is consistent and accurate and had a good vantage point of it. I have concerns about.
By the way, were you satisfied with that?
No.
Why not?
Well, the person has given the statement multiple times, and it appears to have changed over those times. It also appears that the person observed this vehicle from a distance, and also the identification of a Ford Edge seemed highly suggestive the way that I had read the account of it. If I had done that as a police officer, this court would throw out that identification.
So, did you find out anybody in the Albert family, for instance, on the Ford Edge?
I don't recall off the top of my head if somebody.
Did you look at automobile registration records?
I did not know.
Did you task anybody else to look at automobile registration records?
I believe Trooper Proctor and Sergeant Mechanic had investigated that.
And do you have any idea what that investigation revealed?
I don't.
Did the Alberts own a Ford Edge?
I don't know as I sit here.
They did own a Ford Edge, didn't they?
Objection.
So the objection is sustained.
Yeah, that's a comment.
But nothing was done further that you're aware of to investigate the circumstances of that Ford Edge being seen and placed in front of 34 Fairview, right where the body was found, between 2:30 and 3:30 in the morning, right?
An investigation into the reliability of that witness was conducted.
So you just decided, and that investigation, folks, is, I didn't believe him, right?
No.
Yes.
Are we almost at the end?
That's all I have.
Okay,
Mr. Lally, anything?
redirect.
Just briefly.
So as far as that last line of questioning, as far as the witness in the Ford Edge, you mentioned that there were several different stories, correct?
Yes.
Several different versions of a statement.
Yes.
And what were those different versions?
The first was that this person saw a Ford Edge in front of 34 Fairview. The next one that I can recall is that the person stated that they were not on Fairview, but on Cedar Crest, some distance away, looking at this vehicle in a blizzard. Person also self-reported that he was colorblind, and he was operating a larger motor vehicle. The third story was a concern about the time. The third story was as he arrived, the Canton Police had the street blocked off at about 4 a.m. and he places this Ford Edge outside the residence at a time before that. So we know through our investigation that the Canton Police didn't arrive till shortly after 6 a.m. So the witnesses' times are off as well.
As far as what you termed as a highly suggestive ID with the Ford Edge, can you explain what you mean by that?
As I read the report, the investigator had asked the person first a question. They stated that there was a vehicle in front of 34 Fairview Road. The witness was then brought outside, and the investigator allegedly pointed to a motor vehicle that was in a parking lot, and it said, "Is that it?" And the witness said, "Yes, that's it." And so it's suggestive in the fact that it would be a single photo identification, which, you know, as a police officer, I would not give somebody one thing and be suggestive, "Is this it?" Because as the courts have ruled, that's highly suggestive, and the person's more likely to adopt that description of whatever they're describing, opposed to if you use other methods.
Now, when you were being asked on cross-examination about certain distances from the house at 34 Fairview to the area where you had recovered items, repeatedly you had been asked about a distance of 30 feet, correct?
I did.
From the items that were recovered and the area that was described to you as where Mr. O'Keefe's body was located shortly after 6 a.m., is that 30 feet from the house?
No, where the items were a little further on the edge of the property, so it'd be closer to 40 or 50 feet.
And as far as where Mr. O'Keefe was located with reference to the curb, with reference to the street, how close was that?
From the curb, reports was about 10 feet from the curb.
And so the evidence was a lot closer to the roadway, a lot closer to the curb than it was to the house, correct?
Objection.
Sustained is
As far as what, if anything, did you find significant between the location of the evidence in relation to and Mr. O'Keefe in relation to the roadway versus in relation to the house?
The pieces of evidence were physically on the roadway, on the pavement, or the curb.
Just one question as it applies to the Sally Port video from the Canton Police Department. Are you aware of sort of how those videos were recorded as far as when they stopped, when they started?
Not off the top of my head, no. But the ones we have in possession, no.
As far as, and I'm sorry, let me ask the question probably a little more succinctly, but with reference to, are you familiar at all with the camera system at the Canton Police Station?
Vaguely, yes.
As far as, do you know whether or not it's motion active?
The Canton IT director stated that it was.
So the objection's sustained.
So let me ask you, are you aware that the cameras are motion activated?
Objection.
As to form, it's sustained.
What, if anything, are you aware as to how the cameras record?
Objection.
I'm going to allow it.
Move your approach.
Okay?
You are
Whoops.
muted.
Okay, fast forward, fast forward, fast forward.
Now, Lieutenant, when it came to the Sally Port video, at some point you did review them to some extent.
Yes.
Now, over the course of your review, what, if anything, did you note in reference to time? Was it sort of one long consistent, or did it jump?
It jumped.
And based on that, what, if any, conclusions did you draw as to how that video recorded?
It appeared to be motion activated as these jumps occurred. It appeared to be triggered by motion.
Now, with reference to the items that were recovered on January 29th during the 13th search that you were present for, in addition to your police report, how, if at all, were they memorialized?
On the exterior of the paper bags that they were contained in.
And when was that done? Before or after February 10th, when your report was written?
Objection.
Ask me differently, Mr. Mullin.
When was the memorialization on the evidence bags done in relation to when you wrote the report?
Objection.
I'll allow it.
The difference would be the notes on the outside of the bag happened at the time of collection, and then I wrote my report 11 days later.
So, as far as your memory, as you sit here and testify today and yesterday, as far as the items that you took out of the bag, are those the same items that you recovered or were recovered by the search team on January 29th?
Yes.
Now, the information from the call detail records that Mr. Jackson presented to you, there was essentially two little columns, correct?
2 rows, yes.
Rows, excuse me. And was that sort of the entirety of what you reviewed as far as the call detail records in relation to generating the slides that were depicted to the jury?
No.
And, sorry, may I approach you?
Yes.
May I see the exhibits? I'm sorry.
These are not marked.
The witness, Your Honor?
Yes.
Showing you now, it's been marked as Exhibit 577 with reference to what Mr. Jackson had given you earlier. Lieutenant, from what's depicted on there, what, if any, issue do you have with the depiction on that exhibit?
Like I mentioned, it's difficult to get a good sense of what we're looking at because the roads don't really appear on here. If they do, they're light and faint. There are the large black line kind of intersects with a lot of them, with the words of them. At the bottom, it looks like it's written map scale next to a scale, but I can't attest to the veracity of that. Those would be a couple problems I see.
Now, with reference to the slides that you created with the different time frames, not just the one single time frame. Again, the times that you observed or the location of the handset, the cell phone of the defendants that you observed from the call detail records, were they consistent with other pieces of evidence that you had, whether it be video and or witness statements?
Yes.
And that would be consistent with the location of the defendant, correct?
Yes.
Now, you were asked some questions about speed and distance traveled. You indicated that you did not agree with the premise of Mr. Jackson's question, correct?
Yes.
Can you explain to the jury what it was about the premise or what it was that you did not agree?
So while I agree it would be impossible for the phone to travel at that distance, I disagree with the premise that the procedure that was being captured here and the distances may not be at the same time. So there may be the distance could have preceded the procedure and the end distance could have been after the procedure. There are other ways to capture that information. Again, all I'm doing, and I'm at the mercy of the records, is illustrating them. I then take the next step in order to corroborate that information, ideally through video and other location-based information.
Now, in relation to speed, is that something that you've done in other cases with call detail records?
Yes.
And you mentioned that you weren't able to do it here or didn't do it here. Can you explain why not?
By speed, do you mean route of travel or?
Yes.
So if I have a more robust set of records, so again, we're at the mercy of Verizon here. We only got a limited number of records from the ranging data. With other cases, if the phone is much more chatty with the antenna, if there's more lines of communication, I've seen lines of communication as frequent as every couple of seconds or less than a couple of seconds. As I map those out, I can make more of a determination of maybe the route of travel of the cell phone. So as I put the first arc, I'll then place the second arc on a map and say to myself, how could a handset get from the first arc to the second arc? And I'll have a number of possibilities. I will then lay out the third arc. Okay, how could a phone get from the second arc to the third arc, and repeat that process, narrowing down the different possibilities. And oftentimes I'm able to determine the route of travel, send investigators down to that route, and we find corroborating information.
And again, why was it that you weren't able to do that with this information that you received from Verizon in this case?
We received a limited number of entries in this record.
And what, if any, relationship does that have to sort of the area or the geographic location as far as the town of Canton is concerned and the number of antennas there?
Well, as respective to the number of records, it's a larger area the cell phone could potentially be.
So in no way in your
So, in other words, it's probably going to be less accurate. You can't really draw that much of a pinpointed conclusion as to where she was from this information. That's the conclusion that you have to reach based on what he just said.
testimony in your slides or anything else, are you suggesting that the device or the handset or the defendant's cell phone was traveling at that speed, correct?
Correct.
So could you explain to the jury again exactly what those arcs mean and what you are explaining with reference to those?
Those records have a start distance and an end distance. I take those distances, place them on a map, starting where the antenna, there's also in that record, states it is. Draw a distance from that antenna, draw an arc at that distance with the radius being the distance that's on the record, and have an arc that's in excess of 120 degrees.
You also asked some questions about whether causing some sort of interference or something in relation to the recording with regard to antennas or which antenna a device might connect to. You indicated that was not your experience with these types of records. Can you expound upon that?
The greatest predictor of what antenna a cell phone is going to use is distance, because like I said, the farther the handset is away from an antenna, the more degraded the signal is going to get. So that's the best predictor. But like I mentioned earlier, there are things that can disrupt a cell phone signal, which would cause a handset not to connect to the closest antenna. And that can be physical obstruction, precipitation, elevation, an antenna goes down for whatever period, for whatever reason, causing it to connect to another antenna that is technically further away.
And so from your review of the call detail records and from your mapping from those various timeframes contained within the slides presented to the jury, what, if anything, can you say from that material in reference to the other evidence collected as to the location of the defendant's cell phone during those relevant time periods?
Well, relevant, I'll zero in at 518. I would suggest that the defendant, her vehicle, and the cell phone were on Washington Street outside of Temple Beth Abraham at that time. That's one thing that I would be comfortable suggesting.
Also, really, really quick, Peter Beveridge, thank you so much for becoming a member on YouTube. Welcome to Bike Club. Very happy to have you here. Thank you so much for supporting the channel. Folks, if you guys are really enjoying this coverage, consider becoming a member on YouTube or a supporter on Patreon. It's really what helps to bring in consistent sort of resources for me to be able to put those resources directly back into the channel and bring you guys content like these live stream trials and the recaps and everything, paying for an editor, being able to dedicate my own time to this, analyzing this case and other cases that are going to be coming up and other legal topics coming up as well. So thank you so much, Peter, for doing that. And if you guys are not in a position to join Bike Club, zero shade whatsoever. If you can just like the video, that really, really helps to push it out to the algorithm so that YouTube sends it to more people so that they come in and join and watch. So, and then we get AdSense from all of that. So that directly translates into also supporting the channel in that way. So thank you so much, Peter, for joining. Welcome to Bike Club. Hope you can join us for our next members only live stream. Typically Fridays at 10 a.m. East Coast time. I'm traveling this week, so I'm going to have to do like a double Bike Club member stream next week to kind of make up for it. And then you get other benefits as well, like outside of the scope of trials. When I've got uploads that I put up on different subjects, I will give Bike Club early access to it. If you are a supporter on Patreon, you also get ad-free access to those. So there's all kinds of stuff that you can get from being a member. And of course, when you're in the chat, you've got the member emojis as well that you can throw into the chat, like the chinchilla of evidence and things like that. And you guys, we are also getting very close to 245,000 subscribers. So how insane would it be if we could get to 250, 250,000 subscribers by the end of this trial? I think that given that we've got another 2 weeks left, I think it's possible. It's definitely possible. So if you also are not a subscriber to the channel, consider subscribing, joining us in this crazy journey that we're on this channel and on YouTube. So lots of ways that you can support if you are not already, and according to what you're capable of doing. So yeah, thank you so much, guys. Thank you. And let's see how many likes do we have on this at this particular point. Did I see that one of the mods, Mountain Princess 207, said we are close to 500 likes. Can we get past 500? That would be awesome. That would be fantastic. Okay. All right. Let's continue back with the testimony here.
Can I have a moment, John?
Yes.
Can we? All right.
Thanks, sir. Nothing further on.
Jackson?
Very briefly, Lieutenant Tully, you still have, I think it's 578, using 578.
I have 577.
Is,
Yeah, 578 is not marked yet.
what's up? Where's the RTT record? Is that 577?
I have RTT records that are not marked in front of me.
May I approach?
Yes.
Move to admit.
So,
Objection.
right. So let's mark it for identification. Allison.
Thanks, Hazo1. Yeah, let's get to 500 likes and 250K subs.
Just have the witness identify it.
Understand. I'm sorry, then that was letters.
Triple K.
Thank you. You're looking at triple kilo, correct?
Yes, sir.
When you created the arcs on your map, you also put on the map 5:18 a.m., correct?
Yes,
Where'd you get that number?
from the procedure start and end time
So you did use the procedure start time and end time, correct?
to denote the time, but not, to denote the time on the slide. Yes,
Time of the event, correct?
yes,
All right, so the 5:18-19, I'm sorry, 5:18 and 19 seconds, and then I don't have it in front of me, but 0.154, I think. Is that right?
yes,
That was the time that you used to establish that the device was on the first arc, correct?
no, I didn't use it to establish the arc. I used the distance to establish the arc, and I placed the time on the slide.
What time, Lieutenant Tully?
5:18.
The time that Verizon gave you as the start time, correct?
Yes, they're both 5:18.
So there's a start time and a start distance from the tower. In other words, the event took place at this distance at this time starting, correct?
No, you're using the wrong words. It says first distance.
I'm not using the wrong words.
Yes, sir. You said start distance. It's first distance.
Okay, fine. Okay, pick the words. First distance. Start time and first distance, correct?
Yes, those are on the record.
Right. Then Verizon gives you an end time, correct?
Yes,
And last distance, correct? Yes. And you created your arc based on the start time and first distance versus the end time and last distance, correct?
no, the time weren't associated.
If you're saying no, is because that would require the device to travel at 135,000 miles an hour.
Objection. If the witness could please answer the question.
So let him finish,
Okay, sure.
and then the objection to that is sustained. You can ask it differently.
Go ahead.
The times were not part of the depiction of the range. Well, I will suggest to you that it is probably unbelievable that those are actually start and end times. What I'm saying is we don't know for certainty that that is the exact time, the first distance and the last distance. I'd have to look back at the records, but I also say that we have corroborating evidence to say that that is accurate.
So you have to look back at the records, correct?
Yes,
That is your record.
No,
That's what you looked at, isn't it?
the record's key.
And where's the records key?
They were provided by Verizon.
Where are they, sir?
I don't have them in front of me.
Right. That's all.
Okay,
May we approach this briefly?
okay.
All
Don't
right.
leave yet, Detective.
Brief approach. In the meantime, Hazo1, thank you so much for gifting 5 Legalbytes memberships once again. So kind and generous. One of our awesome mods as well. Simon McDonald, Angry Grape Stoner, Marmite, Paige Price, Sleepy Sloth. You have all been gifted memberships from Hazo1. So welcome back to Bike Club. Very happy to have you all here as well. So thank you so much, Hez. Very, very kind of you. And we've got some more questions that we will definitely be getting, but it feels like we are getting towards the end of the morning session, perhaps, unless we start to call another witness. Maybe we'll get a little bit of an early lunch. We'll see. We're going to fast forward through this part. Next witness.
All right, your next witness, Mr. Lally.
Yes, Your Honor. The Commonwealth calls Sergeant Brian Gallerani to the stand.
Sergeant Brian Gallerani from the Needham Police Department. Okay, so this is not Canton. This is not Massachusetts State Police. Interesting.
You swear to the evidence of the court and jury in the case now and here to the truth, the whole truth, and nothing but the truth, so help you.
I do. Thank you.
Whenever you're ready, Mr. Lally.
Thank you, Your Honor. Good afternoon.
You are unmuted.
Afternoon.
Could you please state your name and spell your last name for the jury?
Ryan Gallerani, Gallerani.
And what do you do for work, sir?
I'm currently employed as a sergeant for the Needham Police Department.
And how long in total have you been a member of the Needham Police Department?
I graduated the academy January of 2006.
And how long have you held the rank of sergeant?
Just under a year.
Now, prior to you holding the rank of sergeant, what was it that you did within the Needham Police Department?
I was a detective from September of 2014 to June of 2023.
Now,
Actually, really quick, let's get those questions just to make sure that we get all of those related to this particular witness. James Games Classics, Legalbytes. Can you make a civil case for someone stating an opinion of suspicion like Karen Reed's theory of McCabe involvement, but the same measure, have they not done that to her from the start? Well, it depends. Sorry to start with the most lawyer-like answer possible, but it really does. And a really big part of the answer to that question is the context as to like where that accusation kind of came from. You know, for Karen Reed against the Alberts and the McCabes, this is all in the context of the litigation. This has all been coming through motions and hearings and things like that. So there is a litigation privilege for that. As for the other individuals, you know, I don't know. We would have to look at that on a more fact specific kind of basis. So, possible defamation, maybe not, but you know, is it based on you know, other information that was available? That also goes into that whole inquiry. Mike Olson, question, Legalbytes, great answer about the cameras, but a harder philosophical question from wannabe Aristotle's. Do the cameras make the trials more or less fair? Do the jury follow social media is the question. So they are not supposed to be following social media at all, right? That's part of the thing that the judge says every single day is do not do any independent research, do not look anything up about the case, whether that is on, you know, media, newspapers, or social media. You don't want to be getting tainted by the information that's out there. You want all of your information to come in through the trial. So they're not supposed to. And I think that for the most part, I do think that jurors do maintain that. I think that most people do not do independent research or go looking for any of that information. Sometimes they accidentally come across the information. It's better if they tell the court, and, you know, and they have a discussion as to whether or not they are able to, you know, distinguish what they heard and kind of disregard it. So there is that as well. But, you know, does it complicate things? Sure. I think it does, but you know, it requires a little bit more from the jurors to avoid it. But I do think that overall, I wouldn't say that it's made trials more or less fair. I think that what it does do, however, is it shines a light on our judicial system, and when things are going wrong, that we can see that things are going wrong, that we can see that a judge down in Georgia is like doing things that are incredibly improper and are calling into question other decisions that this judge may have been making, and may actually result in having a judge being removed. Like we have seen that, where a judge ends up losing their job because of the things that they are doing in a high profile trial. We have seen that. We saw that with the Parkland shooter case. She says that she was already planning to leave, but okay, there was a lot of outrage that came before her stepping down from that position, and there was also a reprimand from the basically Judges Association in Florida, for some of the things that she said and did. So that is where, it's great to be able to have this light that is shown on these cases. And it's a lot of pressure to be putting on the people that are involved in the case. I'm not saying that they particularly love it. If I'm an attorney that is involved in a high profile case, I don't know if I love having that many people watching and commenting and watching for every single move. And I'm saying that knowing full well that that's exactly what I'm doing here. If I'm the person in the courtroom, it's certainly much more uncomfortable. But overall, I think that it does serve a very good purpose for maintaining our judicial system and maintaining that things are moving in the way that they should be. James Games Classic, Legalbytes, could they have broken pieces off at the lab for testing? Although you would think that would have been noted already. Yeah, that definitely would have been talked about for sure. That yes. Hawk Wind, Legalbytes, don't they have a tech tasked with this kind of testimony in a case? Well, there probably are some digital forensic experts as well, but you can also have lay testimony that sort of sets the factual groundwork for what was there, what was looked at, and what was actually analyzed to investigate the case. Yara Gillen, Legalbytes, on what grounds can ACW reasonably object to evidence coming in? There are a number of things, like the lack of reliability of like the source of the information, the fact that maybe it's more prejudicial than probative. There are a number of objections that can be made for any kind of piece of evidence. Brad Hopkins, question, why not ask him how he reprimanded Proctor with his bad text? That may or may not be helpful to the defense to get into those details about it, or to the prosecution even. So, if or maybe it's just not worthwhile to get into that level of granular detail on this. Marmite, a thought just popped in my head. Didn't the glass out the pub have a bubble pattern on it? Sure. Higgins stated that. Did the glass found outside have that pattern? The glass did not. It was the bubbling or the ridges or what have you that were found on something was the clear plastic, is my understanding. Unless I misheard that. If that's the case, I would have missed that, but I'm pretty sure he was talking about the plastic tail pieces. L. Borate, Legalbytes, can we split the Lally tally based on direct versus cross? Meaning when we get to the defense's case in chief, yes, we can definitely do that. It'll be a little bit more difficult on the day if there is a switch in the middle of the day, but I'm sure we can figure that out on one day. I can spend a little bit more time on that particular transcript. So yeah, we can definitely do that. Mackenzie Robite, Legalbytes, did that witness really move the needle for either side? For me, no, not really. The cell towers showed something that was basically what we already know at this point. It kind of confirms it, which I guess is, fine for the prosecution. They've got to make their case regardless. But for me, it didn't move the needle either way, really. Jerry Roth, Legalbytes, is it wise for a witness to argue semantics with a lawyer on either side if it's insignificant? Here with this last witness, with Lieutenant Tully, what he was arguing over was the more technical aspects of like how certain calculations were being made and what was the underlying premise of it. And I actually don't mind that. I think that giving some kind of pushback on that is fine. And I think he did it in a way that was very professional. So I think overall, he's one of the better witnesses that we've seen recently from the prosecution. And I think that his pushback was actually relatively valid when he did give some pushback. So I have no problem with it. It didn't seem unreasonable. It didn't seem unprofessional. So, to me, that was fine. L. Borate, after the Haas Long 2 Google search info from the MSP CPD still didn't ask for a search warrant. I guess not. I guess not. Although that did come out quite a bit longer after all of this, but why not? Why not have a search warrant at that point just to say, hey, look, yeah, we did look into it and we found nothing. You know what I mean? Even if it was months and months and months afterwards, they can at least say that they tried at some point. Okay. Alrighty. That is Okay, that is that. Let's get on to the next witness. Okay.
The course of your work as a detective and sergeant with the Needham Police Department, what, if any, training have you received in regard to collection of biological samples?
As part of a sexual assault class I took in January of 2015, I was certified in DNA collection by the Mass State Police.
And can you explain a little bit to the jury about sort of what that certification process entailed, or what it was that you did to become certified?
So I was specifically certified in buccal swabs, which is the process of collecting cells suitable for DNA comparison by swabbing inside of a person's cheek.
And,
Okay. So both, I haven't really talked about much of this because, this was like mentioned and then kind of just like it like washed away in the wind. But there was a mention of Trooper Buchanan and Trooper Proctor having to give cheek swabs, buccal swabs for something or other. I didn't really know what that was for, but they both were required to do that at some point by the Massachusetts State Police. So now we're going to probably find out what exactly that was, why they had to do that, what they were looking for, and what they ended up finding.
Certification, is that up to date at this point?
Yes,
Now, at some point on January 16th, 2024, did you have occasion to collect buccal swabs or samples in relation to this case?
I did.
And fair to say, as far as your work with the Needham Police Department, you had no familiarity or work with the investigation on a Canton Police Department case?
Correct.
Or on a state police case involving incidents that occurred in the town?
Correct.
You didn't know any of the parties involved in the case?
I did not.
And so on January 16th, 2024, where did you go on that day?
I went to the Norfolk District Attorney's Office in Canton.
And who, if anyone, did you meet with, or who, if anyone, did you collect samples from on that day?
I collected samples from Sergeant Buchanan and Trooper Proctor.
And can you explain to the jury just briefly as far as the process of your collection, as far as what physically did you do?
So I physically swabbed the inside of their mouths with a cotton swab and collected the evidence, sealed it up in a buccal swab kit, photographed it, and brought it back to the Needham Police Department.
And when you brought it back to the police department, what did you do with it then?
I entered into the evidence.
And did you do that in conformity, well, the collection and the securing of the item, did you do that in conformity with your training and certification on buccal swab collection?
I did.
Now, with reference to those items, at some point were you informed that those items were to be transported to a BODE technology lab in Lorton, Virginia?
I was.
And were there specific instructions as far as shipping was concerned that were provided by the BODE technology lab?
Yes.
And the shipping that occurred in this case, was that in conformity with what BODE had provided as far as the policies and protocols for shipping those types of materials?
It was.
Thank you, sir. I have nothing further.
Anything?
We have no questions.
All right, you're all set, Sergeant.
Thank you.
Okay.
Have a good day.
Wait. Okay. Okay. So maybe someone else.
Yes, Your Honor. Call Mr. Nicholas Bradford to the stand.
So someone else is going to be testifying about. Okay, Nicholas Bradford from BODE Technology. So maybe they're going to talk about the actual results of the swabs.
Step right up. Watch step on it.
That was the fastest that Lally has ever done that before.
The whole truth and nothing but the truth, so help you God. Thank you.
Forgive me, Your Honor. I have just one moment.
Sure.
Good afternoon, sir.
Good afternoon.
Could you please state your name and spell your last name for the jury?
Yep, it's Nicholas Bradford, Bradford.
And sir, that microphone before you is adjustable. You can place it anywhere that's comfortable for yourself, okay? What is it that you do for work, sir?
I'm a DNA analyst for BODE Technology in Lorton, Virginia.
Okay, you're definitely going to have to keep your voice up, sir. Okay.
Sorry about that.
Now, sir, if I could,
Sorry. It's BODE Technology in Lorton, Virginia.
and for the record, BODE is just spelled as far as BODE, is that correct?
Correct.
Now, sir, if I could just ask you some questions about your educational background, starting with your undergraduates. Where did you go for your undergraduate, and what, if any, degree did you receive from there?
I have a Bachelor of Science in Forensic Biology from Mercy College in Erie, Pennsylvania.
And then following your graduation with that degree, where did you go?
I have a Master of Forensic Science in Forensic Molecular Biology from the George Washington University in Washington, D.C.
And when about was it that you received that master's?
It was around about 2011.
And with relation to your graduate work and your work at BODE, when did your work at BODE begin with relation to your graduate work?
I started at BODE at about 2009.
So during the course of your graduate school?
Yes.
And when you started with the BODE lab, what was the sort of position or what did you start doing when you began?
I was a DNA technician. We assisted the analysts with their case files, and we primarily operated the different robotics and the different processes in the lab.
And at some point over the course of your work there, you then became an analyst, is that correct?
Yes.
And about how much time elapsed or how much time did you spend as a, excuse me, as a technician prior to becoming an analyst?
I was a technician for about a year, maybe two. And then I was in the data banking section as an analyst. And since then, I've worked in the high throughput casework group and the customized casework group.
Now, as far as your work within this particular field, have you had occasion to work in any other sort of labs or facilities?
Yes, for about 3 years, I worked at the Pennsylvania State Police DNA lab.
Now, BODE technology, as far as that lab is concerned, can you describe for the jury sort of what kind of lab that is? And let me ask you first, just about how many analysts work at BODE technology?
Somewhere in the neighborhood of maybe 100 analysts, give or take. We're a small private lab in Lorton, Virginia, and we do DNA work contracted through different police agencies throughout the country.
Now, in addition to police agencies.
Yeah, I think we can probably slow this down a little bit here. I think we can go back to normal. Let's see how this is, and if folks are really in pain over it, then we can maybe bring it back to 1.25. But right now, it's actually going fairly quickly.
Are there other types of entities that would that you would accept or that would send submissions for DNA casework?
Yes, we do some international work with human identification and that sort of thing as well.
Now, as far as the lab at BODE Technologies, is that lab accredited?
Yes, we are accredited through the National Standards Institute.
And can you speak a little bit about that sort of accreditation process and what it means to be an accredited lab?
Yes, so that the National Standards Institute has a set of criteria for DNA labs doing forensic work, and we are audited against those criteria every year, sometimes internal audits and sometimes external audits.
Is that accreditation at the lab, is that up to, the accreditation, is it current as of now?
Yes.
Now, with reference to your work as a DNA analyst, can you describe just in general terms for the jury what it is that you do in reference, what is it that you do in reference to your work as a DNA analyst?
Yes, so we take in evidence that's submitted to us. We process it through the DNA processing. So there are 4 basic steps to DNA. There's extraction, so that's where we separate out the DNA. And then there's quantification, and that is basically just us determining how much DNA we have to work with. The next step is amplification. So depending on the case and the different processes that we're going to use, we're targeting a number of different locations in the genome, and we're going to make millions of copies of each of those locations. And in each one of those copies, there's a little fluorescent tag that we can then detect in the detection step, and that's the 4th step. And then that from there, we have the DNA profile for that sample.
Now, with reference to the lab, as far as training is concerned, you mentioned that you spent at least a year or two as a technician prior to becoming an analyst. What are some of the training, specialized training in this area that you undergo as an employee at this lab?
Yes, so the training program involves a lot of scientific literature reading. There's a practical aspect to it where we're given known samples that we're to treat as if they were casework samples. So we process those as if they were casework. We have written and verbal exams, and we have a moot court exam at the end.
And you successfully completed each of those training sort of portions of, over your course of work with the lab?
Yes.
Are you familiar with a term known as a proficiency test?
Yes.
And can you explain to the jury what that is and how it relates to your work as a DNA analyst at BODE Technology?
Yes. So part of our accreditation is we have to do proficiency testing twice a year. And that is when an outside company sends us known samples and we process them again as if they were casework. And then those results are sent to that outside company, and then we get the results back to see if we are proficient in those technologies or not.
And with respect to yourself, as far as the proficiency testing that you've undergone, what, if any, issues have you had with proficiency testing that you've undertaken?
I've passed all my proficiency tests.
Now, what is DNA?
So DNA is essentially the blueprint for a living thing. It's in most of our cells, and it's unique to an individual with the exception of identical twins.
Now, at some point in January of 2024, did you receive a particular assignment in regard to DNA analysis from a number of items that you received from Massachusetts?
Yes.
And specifically, can you describe the process as far as like when an item comes into the lab at BODE Technology, how it's sort of processed, or how from the time of receipt to the time that the item gets to you? Can you explain a little bit about that process?
Yes. So the item is generally sent via UPS or FedEx. It arrives in our secure evidence room. That room has limited access to only certain individuals. And from that point on, when it's received, a chain of custody is started for that shipment. And anytime anyone touches or uses that item, we need to check it out from the secure evidence room. And then that's all logged on the chain of custody.
Now, when something comes in, is it assigned a sample name or a case number or an ID number in some way, shape, or form?
Yes.
And is it also identified by sort of the corresponding numbers from the external vendor where it came?
Yes.
Now, in reference to BODE case number CCA 2416-0023, did you perform work in relation to that case?
Yes.
And there was a corresponding agency case number of 22-02184, is that correct?
Yes.
And that would have been from the outside vendor, or at least one of them, as far as the Massachusetts State Police crime lab, correct?
Correct.
So there were a number of items that you received. If you could identify them for the jury, what you received, and specifically sort of what you looked at.
Yes. So we received an apparent hair. We received an extract from a taillight from a vehicle, and we received 2 reference samples from 2 troopers from the Massachusetts State Police.
And in addition, was there a sample ID as far as a known standard?
Yes. So BODE gives it our own our own item number. So in this case, the 2 reference samples were CCA 2416-0023 R03, and the same number R04 for the 2 reference samples.
Now, if I could just ask you to further expound upon as far as the CCA 2416-023, which is E01. There was an agency sample.
Oh no, AirPod down. There we go.
ID, is that correct? That was attached to that?
Yes.
And what was that?
So that was 3-6.1.
Is there a description that comes from the external vendor as well as to sort of what that item is?
Yes. In this case, the sample was a shaft end of hair from exterior passenger side rear panel.
There's a specific mass registration plate that's associated with that hair as well. Is that correct?
Yes.
And that was 3GC6A4. Is that correct?
Correct.
Now, with reference to the R03 and R04, those were vehicle samples. Is that correct?
Yes.
And R03 specifically, as far as the agency description, what, if anything, was provided as far as that?
For R03, that was the buccal swab from Yuri Begetic.
And as far as R04?
That was the buccal swab from Michael Proctor.
Now, with reference to the extract portion, that was EO2, is that correct?
Yes.
And if you know when we say extract, can you explain to the jury sort of what you understand that term to mean, or what is an extract as far as what you looked at?
Yes. So when I described the 4-step process earlier, so the extraction was already done prior to us receiving the item. So essentially, the extract comes to us in a tube, and it's a liquid. And provided with that would be the negative control that was associated with it. So from that point, we have the quantification information from the lab that did the extraction. So then we would amplify and then detect the profile from there.
And just to be clear, as far as the EO2 that you were talking about, as far as the extract that you had received, what was the agency description on that extract?
So that was the sample from passenger side taillight with the same registration number, and that was labeled as an extract.
Now, in addition to that, there was a known blood standard, which you indicated was item or agency sample ID 8-1.1.1.
Yes.
So I had thought that the taillight pieces were not swabbed for DNA. And that's what I had thought. Maybe I've just heard that wrong, or they just didn't mention it, and that was an assumption that I made. But I thought that they had swabbed the taillight and the undercarriage, and none of the the tailpipe and the undercarriage, a couple parts of the undercarriage, and they found nothing, no DNA evidence there. That's what I believe Maureen Hartnett had said from the Massachusetts State Police Crime Lab. But okay, but maybe somebody did. That's I mean, I prefer that. I prefer that. We want to know one way or another. Did you check that? And what did it say? Okay. Heather asks, Legalbytes previous tech said swabbed outside but not inside, only parts that would make contact with the outside. Okay. Okay. Yeah, no, that makes sense. Okay. Well, fair enough. All right. Let's continue.
And what was the agency description on the known blood standard?
That would be from, excuse me. Sorry, that was the sample from John O'Keefe, the profile, I should say.
And so when you say the profile as what do you mean by that?
Yes, so the profile was generated by the Massachusetts State Police Lab, and then that profile was given to us to do a comparison.
Now, as far as the profile that was provided, as far as your observations of that, what, if any, issues did you observe in your observations of the profile that was provided by the State Police Crime Lab in Massachusetts?
It looked like a standard single source profile.
Now,
hey, did we reach 600 likes? Awesome. Awesome. Thank you guys. Thank you so much for liking the stream, pushing this out there so more people can watch and join us and spend their time with us. I absolutely love it. Thank you guys.
starting with, as far as there was a STR processing that was conducted, correct?
Yes.
What does STR stand for?
It stands for short tandem repeats. And essentially what we're doing with that is it's the DNA process that we use in forensic testing, where the areas that we're amplifying are short repeats of a genetic sequence that repeat multiple times. And we're just measuring the number of times that sequence repeats. And those numbers together are the profile.
Now, as far as the profile from the, the profile from the extract that you received as far as EO2, from the passenger side tail light of the vehicle, what, if anything, were you able to determine based on your analysis and STR processing of that?
Yes, so we determined that it was consistent with a mixture of 3 individuals, including at least 1 male contributor.
And so if you could just walk the jury through as far as the process, as far as the testing, what is it that you're actually doing in the lab? What are you looking at, and how are you making a comparison?
So once we have the DNA profile, like I said, we're measuring the number of times the sequence repeats at a given location. So we have a series of those. And then we compare that to the reference profile that we were provided, or that we generated for the two reference samples that we actually processed. And then we determine if it's possible that the individual whose reference profile it is could be a possible contributor to that mixture profile that we got from the evidence. And then we need to do a statistical calculation to determine the strength of that possibility of an inclusion.
Let me ask you a little bit about, as far as that statistical calculation, how is that done, or where does that come from?
So in this case, we did what's called a likelihood ratio. Essentially, what we're doing is comparing two explanations for the DNA profile that we observed. So if we have, say, person A, one explanation would be that the DNA profile is a mixture of person A and two unknown individuals. And then the other explanation would be that it's simply three unknown individuals and it's not person A. So then we compare those two explanations of the profile and determine which one is more likely.
Now, as far as the sort of reference samples that you had the DNA profile of John O'Keefe, correct?
Correct.
And I'm sorry, before starting that, you had the extract with DNA profile with multiple contributors from the tail light.
Yes.
So then you have the known blood standards or DNA profile from John O'Keefe, correct?
Yes.
And then you have the buccal samples from Yuri Buchanan and Michael Proctor, correct?
Yes.
And so with reference to those specifically, as far as the reference samples, is that what you're generating the DNA profiles from?
So we're comparing those references to the mixture that we obtained from the tail light. Yeah.
And so in your comparison, let me start with the known one as far as John O'Keefe. What, if anything, could you find from your comparison of the John O'Keefe DNA profile to the DNA profile from the tail light?
Yeah, so in this case, when comparing the John O'Keefe profile, assuming a mixture of three individuals, it is at least 740 nonillion times more likely to be observed if it originated from John O'Keefe and two unknown unrelated individuals than if from three unknown unrelated individuals. And we provide a sort of verbal qualifier to that because most people probably don't have a lot of experience with nonillion. So in this case, that would be very strong support for inclusion.
If you know nonillion, how many zeros are we talking?
So that would be the number with 30 zeros.
And so that would be a strong support for inclusion, correct?
Yes.
Now, with regard to your comparison, with regard to your work as a DNA analyst, is there any kind of software that you use in the course of your analysis with regard to an SDR mix?
Yes, when there's a mixture profile, we often use what's called StarMix, and it's essentially a computer program that we input the DNA profile, and it allows us to use a series of mathematical equations to help us interpret that mixture.
Was that done in this case as well?
Yes, and then we use that same program to run the statistics.
Now, with regard to the sample, the buccal sample attributed from Yuri Buchanan, did you run that for a comparison as well?
Yes.
And what, if anything, were your findings in relation to your analysis of that?
So in that case, assuming a mixture of three individuals, the DNA profile obtained is at least 46 million times more likely to be observed if it originated from three unknown, unrelated individuals than if from Yuri Begenik and two unknown, unrelated individuals. So that sounds confusing given what I just said. So the verbal qualifier for that would be very strong support for exclusion.
I'm sorry, very strong support for exclusion, is that correct?
Correct.
And then similarly, as you were testifying, what, if anything, did you find from your analysis comparison of the buccal sample or DNA profile from Michael Proctor?
Yes, so in that case, assuming a mixture of three individuals, it is at least 76,000 times more likely to be observed from 3 unknown unrelated individuals than if from Michael Proctor and 2 unknown unrelated individuals. So that would be strong support for exclusion.
So correct me if I'm wrong, but your findings with regard to the 3 samples is strong inclusion or strong support for inclusion of John O'Keefe, is that correct?
It'd be very strong support for inclusion.
And strong support for exclusion of both Yuri Buchanan and Michael Proctor, correct?
Correct.
Now, sir, in addition to that, you had mentioned that there was an EO1 sample that was a shaft end of a hair from the exterior passenger side rear panel of that same vehicle with the same Massachusetts license plate, correct?
Correct.
Now, with regard to DNA as it pertains to hair samples, can you describe for the jury sort of that process and so what is it that you're looking when you receive a hair sample as far as an extraction is concerned? What is how does that process work, or what are you getting that extraction from?
Yes. So when we have a hair, generally we'll take a look at it, and a forensic biologist will give their opinion on if it's likely that we'll obtain a profile from that hair, because hairs can be a little tricky. So in this case, the forensic biologist determined that the hair would likely not provide a great profile from STR testing, but we went ahead with it anyway, just because sometimes it does work. But in this case, we extract it, and that involves dissolving the hair and forming an extract like the other samples. And then we quantified the hair in this case, and the quantification that I used targets what is called autosomal DNA or nuclear DNA. And in that case, the results were below the limit of detection. So we did not process that sample forward for STRs because we would not have obtained a useful DNA profile from it.
Sir, if I could just take it back a little bit in that. Earlier in your statement right there, you just indicated that hair samples or DNA from hair can be a little tricky. Can you expound upon that and explain to the jury sort of what you mean by that?
Yes. A lot of times, hairs are, unless they have a root attached, they're not a great sample for nuclear STR testing. They can be, but it's sometimes hit or miss.
As far as what's actually being tested as far as STR when it comes to hair, it's not the actual hair. Is that correct?
I'm not sure I follow. Can you?
Let me ask you this. You're familiar with the term follicular tissue?
Yes.
Okay. Can you explain to the jury what that means in relation to a hair sample and DNA testing?
Yes. So when there's a follicle attached, that's generally where you will get the nuclear DNA from, not the hair itself.
And follicle would necessarily be attached to the root end and not to the shaft, correct?
Correct.
Now, as far as autosomal DNA, can you explain what is autosomal DNA and sort of where does that come from within DNA testing?
Yeah, so you can think about that more as nuclear DNA. So that would be DNA that's in the nucleus of the cell. So that's what most people think of when they think of DNA. But there are there's other forms of DNA. So like, for example, mitochondrial DNA that exists outside the nucleus.
And as far as the testing that you performed in regard to this hair sample, that was STR testing, is that correct?
Yes.
And I'm sorry, what were the findings again with relation to the STR test?
Yes. So like I said, we quantified the hair and it was below the limit of detection. So we did not process that hair forward for STR.
Now, as far as that terminology, below the limit of detection, can you explain a little bit to the jury sort of what that means as it applies to the testing that you conducted?
Yes. So the instrumentation has a limit of detection. So there could be potentially small amounts of DNA there, but it's below the limit that we are confident to say that there is DNA present. So we would normally not process those samples forward.
Okay.
Now, that hair sample, as far as
So in other words, the hair that was provided to them didn't have enough DNA for them to be able to make a conclusion as to whose DNA it was, whose hair was it. So that whole thing about the hair that was found on there, we don't know whose it is. I really thought that like my assumption was, well, the reason why they're making a big deal about this is because it's John O'Keefe's hair, obviously, right? So it turns out we don't actually know. So what we do know so far from what he's testified is the taillight swab that they took. They tested for 3 people. This is why they took the cheek swabs for Yuri Buchanan and for Trooper Michael Proctor, is to see if their DNA could be found on it. And it said that the taillight pieces that were swabbed, or the taillight part that was swabbed, had a very strong support for inclusion by John O'Keefe, meaning that his DNA was found on the taillight, but that Yuri Buchanan's and Michael Proctor's were not found, or at least there was very strong support for exclusion. And in other words, very strong support for them not being present. So, so that's what that is saying. Now, what can we possibly conclude from that? Does it mean that the taillight absolutely hit him in that moment? Maybe it means that earlier in the day he happened to swipe his hand across the back of the SUV on his way over to the passenger side when Karen Reed was driving him to the bar. I don't know. That there could be a number of reasons why his DNA would be on that taillight, because he happened to be around this car quite a bit. So, but that hair not having any or enough DNA in it in order for them to conclude was very interesting to me.
One that you tested, you mentioned that it was not initially advisable, I guess, for STR testing, and just went ahead and did it anyway because sometimes it works. Is that correct?
Yes, it's usually worth a try.
And then beyond that, that hair sample within your lab, as far as BODE technology, was that given to a different analyst for a different type of testing?
Yes, we decided it was worth a try to do mitochondrial DNA testing on the hair.
And is that a type of testing that you yourself perform?
No, that would not be me.
And why would it not be?
I was not trained in mitochondrial testing.
That's sort of a specialized subset as far as different training and different type of testing that occurs?
Yes.
Just in general terms.
Okay, so maybe we'll get a conclusion as a result of the mitochondrial DNA testing. We'll see.
If you know, could you explain to the jury sort of the difference between what you've termed as nuclear or autosomal DNA versus mitochondrial DNA?
Yes, so very basically, the nuclear DNA is the DNA that exists in the nucleus. The mitochondrial DNA is the DNA that exists outside the nucleus in the mitochondria. And the mitochondrial DNA is inherited directly from the mother. So if you were to test maternally related individuals, they would have the same mitochondrial profile.
And that other analyst that conducted the mitochondrial DNA, familiar with who that person is?
Yes, that was test chart.
Okay, one moment, Charlie.
Sure.
Is that going to be the next witness? Because there is another BODE witness.
Thank you very much, sir. I have no further questions.
Okay.
We have no questions.
Great. So you are all set, Mr. Bradford.
Thank you.
Thank you very much.
No cross-examination.
Okay, so the jurors, we will take our luncheon break and we'll have more witnesses here for you this afternoon. So let's say 40,
45
All
minutes.
rise to the court, please.
And this
Your Honor,
was
may we approach?
25
Sure.
minutes. So we've got about 15, 20 minutes then until the next one. Okay, so we're going to get this to live. So it's over here. It's so 10:30, 10:40, 10:40, 10, or sorry, I'm California time. So 1:40, 1:45 p.m. East Coast time. Let me write that down to just in case. Okay, so no cross-examination of this witness either. Very interesting. Another power move by the defense. We've got some questions here that I will answer, and then we will close it out and move on to the afternoon stream. This will redirect right into it, and if it doesn't automatically redirect you, we've got some links that are actually already posted to social media for it. Ooh, and also let me make sure that I make that video live. or public because it's unlisted. Let me see here really quickly. Meant to do that earlier. So many details. Oh, and also I've got to change the time. 1 second here. One more thing. Okay, there we go. All right. So this will be redirecting right into it. That all should go very smoothly. And the poll, thank you guys also for reminding me of that. I see that, Mark Smith. Let's end that right now before I forget. Okay, here is the result of the poll. Where is it? Is it going to show me? Are you actually going to show up? I just ended it. Come on. What just happened? Hang on. Let me see if maybe it just the chat is being funky. Okay, there we go. Going into day 24, how do you lean regarding KR's murder charge? 87% said not guilty. 8% said need more information. 4% said guilty. And this is 1,900 votes. So we're about where we were yesterday and the day before. So yeah. All right. Good stuff. Okay, let's get to some questions here, and then we're going to have a quick lunch break, and then we will be getting on to the afternoon stream. Oh, we've only got a handful of questions. Okay, so there we go. Firefly Bakery Sweets, Legalbytes, you should do an as far as search also in the videos. He says that just as much as what if any. That is also true. And sometimes he does that multiple times in a sentence. Also, that is one that I definitely should do. I mean, I've already got the transcripts. I all I have to do is go back and use the search function in those. And I'm gonna have some serious time on airplanes when I'll be sitting and maybe having good internet, maybe not. So that is definitely something that I think I can probably do by the end of this weekend. I can probably do that. I will add that to my list and see if I can get that done as well. Derek P. Legalbytes, do you think this jury should have been sequestered? I think this is the highest profile case I've seen in the last 10 years. I live in Massachusetts, all over it's all over the news station and the radio station. You know, it takes a lot to sequester a jury, a lot of resources. You're also separating these people from their families, from other responsibilities that they may have. So it's to sequester a jury, you really, really, really have to need to do so. And it's also state resources that go into it. So that's just, it's a lot that has to go into it. And so, like I said, you really have to need it in order to get there. It's sequestering a jury is not done lightly. Oftentimes what will happen is when a jury needs to be sequestered, they will do so at the time of deliberation. But even then, it is quite a bit. I mean, we're like we've been at this trial for like 2 months now. Sequestering them for that long that's just a very long time to sequester them. And I have seen other similarly high profile trials. I mean, the Johnny Depp trial was arguably more high profile than this one even. I mean, that one was absolutely all over the place. So jury was not sequestered there either. So, and also just to as a follow-up question to that, Reznov Vasilevsky, what does it mean to sequester? It means to separate the jury, basically have them stay in a hotel. They're not allowed to contact anyone. They I'm pretty sure they give over their phone numbers, or not phone numbers, their phones. Like they basically are limited. They're very limited in the ways in which they can contact their family members. And they've got people that are like cops that are standing guard to make sure nobody contacts them. It takes a lot. It takes a lot to sequester them, and it's a huge pain in the butt for everyone involved, most of all the jurors. So I would never want to be on a jury that is actually being sequestered. Oh, also this super chat, Grinning Llama, thanks so much for the super chat. I missed this earlier. I can't imagine being a juror in these trials and having the responsibility of someone's liberty because this testimony is making me so lost. Yeah, there are parts of it here that are confusing, right? I've had to go back and kind of listen to some of the testimony again to make sure that I'm not getting confused. Jury can't do that. They can't hit the back button to go back 5 seconds and try to listen to an answer again. They can't do that. So there are parts of it that I would imagine are challenging in real time when you're not actually streaming it. You're not watching it on a video. So I agree. It's very challenging. Veronica B, question: isn't this tiring for your back, Alita, going all day today? Well, I will say that when I was on the island in the hotel, it was a bit more challenging there because it was like a wicker chair. It had pillows and stuff to try to make things more comfortable, but it was still not the best. This chair is a bit more ergonomic, so it's a lot more comfortable for me to sit for a number of hours. And when I get back to like my actual office where I've got like a brand new, like really ergonomic chair, it's even got a footrest. That one is going to be even more comfortable. So that is going to be totally fine. But this one is like from IKEA or something. This one is even fine. So, but thank you so much. Scott Stevenson, question: why haven't they tried to pinpoint exactly to when the video was mirrored and by who? Well, the defense has tried to figure it out. It seems like they've been asking people, like, who was the one that actually like got the surveillance footage from the camera or from the system, they've been trying to ask about that. They haven't quite gotten a clear answer yet, but it just kind of seems like there's a lot of people that are like, well, I don't really know. And so I don't know. You can only get such great answers if people are not going to really be helpful beyond a certain point. So defense has tried. So far, it's they've got more questions than answers on that. Doctor Who 8675309. I saw the trooper's direct testimony where he said he admonished Proctor for his garbage. Did AJ go after him about that? Did Proctor receive just an admonishment for that garbage? No, that's not a point that I saw, that I at least noticed him go into. I'm pretty sure he didn't. And the thing is, like, I mean, how did you react to that, to hearing that? Just a basic reprimand? Like, that's it? The jurors may have a similar reaction as well. So they may be thinking like, that's it. You just reprimanded him and then moved on and kept him on the case. You didn't transfer this to somebody else after you found out what had happened, or like, okay, slap on the wrist, fine. They may have a similar emotional reaction to that as other people do. Or maybe they'll look at that and be like, okay, he was reprimanded. Moving on. I don't know. Maybe one of the reasons why the prosecution or the defense didn't really go into that in detail, it could be because that would start to get into the territory of the internal investigation into Trooper Proctor. So, and from all reports that I've read, at least, it's been reported that it's not clear whether that internal investigation has to do with what's happened here, or if it had to do with something entirely different. I don't know. It could be good or bad either way, right? Like, or just bad either way, right? Because either they found out that there's also something else that he did terrible someplace else, or that this was sufficiently bad that finally he got pulled in and looked at. I don't know. Mike Olson, Legalbytes, BODE we heard was civil. Isn't there any difference? As far as an analysis is concerned, maybe, because of the fact that we've got someone's rights on the line, their liberties on the line. Sometimes it's their life as well. If we're talking about capital punishment in a capital punishment case, like the Chad Daybell case. But generally speaking, and that would be one factor, but that's not the only factor, and certainly not the most important factor. Heather S, Legalbytes, I've noticed that on redirect, Lally often gets, you can't ask the question in this form. Is that why he says, what if any, so much? I heard from you, it can prevent a question from being leading. Well, that is a strategy to try to prevent that objection from coming your way. To me, it's still a leading question. Or at least, well, not necessarily a leading question. it seems to be a crutch so that he's not asking a leading question. Whereas he could just ask, instead of saying like, what if any snow was on the ground? You can say, was there snow on the ground? It's a yes or no question, but it's not really leading. So it's just a crutch that he seems to have developed over time. And I think that when he gets to redirect, he starts to get a little bit, not lazy, but he kind of slacks off a little bit on the questions that he asks. He kind of wants to get right more to the point. And that's why he ends up getting these objections, because he actually is leading quite a bit with those questions. Doctor Who 8675309 Legalbytes for the video mirroring. The witnesses are going full Shaggy on this wasn't me. Yeah, that's exactly what's going on here. They're just like pointing at one another. It seems like, or maybe not at one another, but just off in some other direction, that maybe there is someone over there, maybe not. Sarah JH Legalbytes question: has prosecution moved you at all today? No. I mean, to be fair, neither has a defense. There's nothing that has moved me one way or another through the testimony today. I think that the cell towers are fine, but it doesn't change how we understand the events that happened on that night. I mean, I guess the prosecution was trying to say that she had also gone, like, kind of circled back to 34 Fairview Road. But even as they were explaining that, it didn't seem that way to me, because it seemed like between 5 and 5:30 or 5 and 6 a.m., she wasn't pinging those other towers that were over by 34 Fairview Road. She was pinging the ones that were over by Jen McCabe's house. So, on cross-examination, the defense pointed that out. And so that was fine. That was actually the first instance that I was like, oh, is that what the prosecution was trying to say? Because I didn't get that from the direct examination. So, to me, nothing has moved me one way or another at this point. It is interesting that they did find John O'Keefe's DNA on the taillight. Does that mean that DNA transfer happened at the moment that she supposedly hit him? Not necessarily. That could have happened at any point in time from the last time she washed her car and when they went on a trip to the grocery store, for example. Like, that's the issue with, like, touch DNA, is like, when we're talking about someone who has been around that item quite a bit, you don't necessarily know when that DNA was transferred. It's much more helpful when you have someone that doesn't have very many opportunities to come in contact with that thing. So, for example, like, I keep mentioning the forensics from the Caitlin Armstrong trial in Austin, Texas. That one also had touch DNA that was on the victim's bicycle. And there are like zero opportunities for the defendant to have touched the victim's bicycle, which was a very expensive bicycle, like not one that you just leave outside. It's one that you absolutely, and it was like her main tool for her profession. And she was a very successful cyclist, the victim was. So this is a very important item to her, one that she definitely wanted to keep housed inside, away from someone possibly coming and stealing it from her. There are homeless people who will steal things in the area, like bicycles, especially, one like that. Anyway, so the touch DNA on that was much more compelling because the defendant never came in close contact with the victim. It was like maybe by text message occasionally or something like that to like essentially stalk her. And then otherwise, like, so that was much more compelling to say, like, you've got her DNA right there. Like, you've got her planted right there with the item. So anyway, so there it can be compelling, but where someone has been habitually around this other item, it doesn't necessarily tell us that much. It absolutely can help with the prosecution. With that, it would be much more detrimental to the prosecution to have that area be absent of DNA than it is detrimental to the defense to have that DNA be present in that area, if that makes sense. So, but yeah, overall. Doctor Who 8675309 Legalbytes problem with the internal investigation into Proctor. No matter the findings, the union will have his back. They will fight tooth and nail for him, no matter how vile of a human he is. Well, and that's why having these cases be broadcast can also be helpful, because if there's enough public outrage, that the department can also be pressured into either giving harsher punishments or allowing an external investigation into it. So maybe not. We'll see. I mean, there is only so much that things can change also sometimes, unfortunately. That's also the sad part of things, but there's a greater chance of it when you have these cases that are being televised, when you have serious problems that are being revealed by these trials. That's an opportunity that can happen here as well. Sharply opinionated, Legalbytes. Even with the admonishing for the text, we never heard that he was reprimanded or admonished for drinking with Kevin Albert with his work vehicle, and KA's gun and badge were lost. Yeah, we didn't hear about anybody getting reprimanded for that. Of course, maybe Kevin Albert has since been reprimanded for losing contact with his badge and his gun for a period of time after getting super drunk and driving in a police cruiser while drinking, and maybe also Trooper Proctor also got reprimanded for that on the side. We at least didn't hear about it. It would be nice to know if these guys are in fact getting punished for such reckless behavior. But cool. Right? That was a fun little thing to learn about as well. All right, folks, that is the last question that I've got here. So we are going to wrap it up. And actually, it should be starting in about like 5 minutes, maybe. I do see that the fan is back. It was previously at like the court TV little blurb of like, we're going to be right back. So I'm going to end the stream. It's going to go right into the next one. It'll probably come on in the next like 5 minutes, perhaps. I will probably come on just a couple minutes after that so that we can, speed through Lally testimony a little bit, or a Lally direct. And I'm going to get some food in the meantime. So, all right, guys, thank you so much for joining me once again. This has been absolutely fantastic. Thank you to all of you who are joining as members, who are super chatting, who are just chatting, either in the chat or on replay, in the comments. Thank you to everybody for watching with us. Thank you, of course, to the mods for all that you guys are doing to help the channel. So that's it. Okay, guys. Thank you so much. I'll see you in just a little bit for the afternoon stream.